was putting her on the phone and allowing Ms. Daly to go first with Mr. Raphael. And then hopefully she'll get here by time.
It's acting like our stuff is about 8-1 to get out, and then 8:02 or whatever.
Yes.
With the amount of cross that they were anticipating,
Yeah.
I think it might be much more economic to let them go first. I don't know that I'm going to have much of anything. I don't want to. They have a pretty robust cross. I don't want to.
Unfortunately, Kim's not here. She had prepared the cross, as I understand it. So, if you have anything that you're ready to do, and I can give you another. I mean, schedule this call for you to go first. So I'd like to go ahead and do that, unless you don't want to.
I would prefer not to. I really think that I can be much more surgical in a very brief cross if we were to wait.
And that's fine.
Otherwise, I feel like I have to cover so much that I would take a lot of time.
Okay. And then I go upstairs and get prepared for my event this afternoon. You know,
Ask her for a date.
yeah, we'll see. Why don't we see where she is?
So we'd be happy to ask David the questions we think Kim might have.
I'd be happy with that too.
We have a good idea.
Yeah, let's find out where she is.
I dialed her number and it went straight to voicemail, so text her.
We're waiting for you, Don.
All right. I guess we can get started. I'll sit right here.
We almost canceled it.
What's that? Traffic at 89. Oh, okay.
Where'd you come from? Awful.
Waiting for a response.
I'm sure she's thinking
Coming out
about
of Burlington on 89, right? By the whale's tails. The wind.
You've got to get rid of those tails. You know what they call that? Tailwind.
I live way out of Lake Champlain. You must be one of them. Okay, of course, which I know very intimately because I'm chair of the planning commission at PRB there, and so I had to represent the town's interest in that case. We're still working on it.
Sometimes that happens. All right, Kim's giving me a call.
Great.
Hey.
Good to see you. What commission? Hopefully not today. Okay, terrific. Good to see you. We're done today.
Yeah.
I'll take that. so I totally forgot.
I'm in shape.
I have to remind Adrian that there's a collegiate connection there as well every now and then. But, yeah, my dad was he was one of the founders of Brown Mary School. Helped establish it.
She's back on the road, just drove by the Waterbury exit. So
students to
get parked all the way up here to that 9:40 before you go down.
Okay, sounds good. Did everybody hear that? We're gonna start up at 9:40 because Ms. Hayden was at a flat.
Oh, interesting,
She's
yeah.
on her way in.
I grew up right across the street. Went to Moses Brown. Grew up playing hockey in Neon Green. Yeah. Yeah. So, another half hour. You have to slow down.
Yeah, really.
I'm glad I didn't tell you it was 75 on the
Yeah.
interstate. I was a little nervous.
I know that you had a hobby interest in meteorology. Is this the end of the art?
This is a worm from the North Valley. Unusually so. I mean, kind of northwest, and then it's gonna after it passes through, it's just gonna be in the 70s. Apparently, and then it's gonna turn much all next week.
So tomorrow's gonna be nice.
Yeah, it's gonna be in the 60s. Wouldn't be surprised if before the week's out there's some frost here and there. Probably not if you put it down.
At 6, and it was 3, and still.
Yeah.
And then at 7.
Yeah, same here. Yeah, it was like 12 keys. It was gray, and it was dry. Check the dog when she came back. She wasn't wet, you know, because she came in pretty quick with this one after the usual barking routine. And then my wife came back. And said, whoa. Yeah, and it's not so somebody was listening to the weather report that said, oh, your chance of showers, well, more than more, but she much more than just a chance.
There's still trucks coming up that just they kick up everything no one can see.
Yes.
Figured that'd be no opportunity for someone away.
Oh, yeah. We it's the depth of cover investigation. Yeah, we don't have how many. Some, I think it's almost down level of interest is sort of some natural but there are the core group.
One contradiction to the weather forecast today is actually the sun is shining because the Red Sox clinched the American League East.
No, it's because,
It's a good day.
it's because the Browns finally won last night.
Yeah, good call. That's true.
And they beat the Jets, which is always good to beat people.
Yes. I'm with you on that. Absolutely.
But the Red Sox thing is good too.
Yeah, it's the burden I bear. Although it's no longer such a burden. The Red Sox had some great teams in the 21st century, as opposed to the 20th century.
people who.
Pennsylvania.
No, Philadelphia, not from Philadelphia, the other side. Dan was spreading that rumor, but
You hate Red Sox fans? Do you want me to move? Oh, you are Red Sox? Oh, I misunderstood that. Okay. Red Sox fans? Red Sox fans? Try going to Yankee Stadium when the Red Sox are playing the Yankees if you want to see some, up in the ante.
John, did you post the video from yesterday yet?
Annette's got to splice them together, but she will today. Send you the
Philly
link.
fans, yeah.
That'd be great.
they take pride in it.
Yeah, it's, when you get into heated rivalry in a baseball stadium, all kinds of fun things happen. And the last time I was at Yankee Stadium, my son-in-law, he was wearing a Red Sox hat. Some guy dumped mustard on his hat from behind. I'm going to teach you for wearing a Red Sox cap at the Yankee Stadium. You heard that. Silly stuff.
It's serious.
Where
She's a utility.
she ran out of gas on 89.
Oh, really? Well, she doesn't have any good luck when it comes to these things. It was a PUC case?
Yeah, we were having a hearing. Yeah, I guess.
I'm sure she got in the
Almost
car
made
and
it.
said, oh no,
It was close.
I'm late, I'll make it.
Yeah, it was like, I think it was between Waterbury and Montpelier or something.
You know,
We almost got there.
those, when you get low on the tank, as you know, it says, oh, you got 50 miles range
Yeah.
left.
Yeah.
And all of a sudden it goes to like, you got 10, you got 5, and you're out. And then you've only gone 20 miles. It's not very accurate.
I pushed it a few times. Always made it.
My wife always pushed that edge, and I said, Joanne, that's, while it's a digital reading and it appears like it's this fine-tuned scientific instrument, it's not.
It's not.
It's,
I
you
would
know,
track it myself and then like say, okay, I think I know where this is. When
Yeah.
it's telling me this, I think I have about that.
Yep, yep. Well, and the way to do it, when you get down to like 50 miles, you go and fill it up. And you know how many gallons your tank holds, and then you gotta
Exactly, you know how much was left. Yeah. Hey, Jim.
How are you?
I'm okay. How are you?
Yeah. Yeah.
Sorry.
You helping out yesterday?
But I never. Yeah.
Okay, I'll have to roll that one there and make it up.
But I can get Wi-Fi anywhere. It's a beautiful thing. It's a beautiful thing.
Certainly, so. It's fun when people
Transition. I'm gonna actually join in practice part-time just to consult and support them. I'm not probably gonna be stepping up to the plate like this anymore. I'm just all for this kind of stuff. My wife's retired and wants to go out and play. You know, she's doing really well. She's much happier now. She's actually teaching again at Champlain College, which she loves. It's really a perfect capstone to a teaching career in the elementary school. She's got master's degrees and all this, and she's taking everything that she's studied, learned, and consulted on, and giving it back to students, and she's thrilled. Thanks for you here. All other thing. Okay. How come I'm getting older and losing my hair and you keep stuff?
Yeah, right.
No fair.
Oh, yes, I will.
This is 45.
Next one is 30.
Yeah, I'm possibly just, they plan on doing this on a regular basis.
And then, page 33, the last sentence, just again, missing a P and a space. Regional, maybe on the land, but
Really see.
Louise looks lovely.
Yeah, yeah.
What'd you do?
She does, doesn't she?
There's a couple of it or so.
Yeah,
She would really stand back.
What's the PUC overlay? Something that's like more.
New Hampshire, it's not their PUC,
It's SEC, who evaluates all the transmission generation.
who killed that who killed,
Yeah, it's the site evaluation place, and it's made up of, it's very interesting, it's made up of representatives of all the applicable parts that New Hampshire state. Which is education, you have transportation, you have public utilities, you have, and DEP, environmental protection.
So how many?
And then you have,
Wow.
2 members of the public, who else? Yeah, and then chairman, and then they have councils as a public that sort of serves the role of the.
but it's not Dr. Grayson.
No. Well, they have a couple of councils, so I don't know that person. The one right now, I can't remember the name of the current guy who's on this case. It's Chris. It's just a very interesting and different dynamic, and they don't use PUC per se. They use similar language, adverse, unreasonably adverse. But they have a little different criteria that are percentages and are more akin to what Maine uses. It deals with, viewer effect and a number of very specific, willingness to return. So there's a couple of steps or issues with regard to evaluating aesthetics. But again, addressing local, state, and national resources of scenic, value. And make sure you are.
Is there like statutory, like beyond a certain
Submit
reduction, that equates to something that you have to pay for? Like there's something that's, there's like a blanket baseline that's covered, and then above that. Oh, that's right.
You're
Are they way this time, or?
But I think it's again part of that process to satisfy and provide an opportunity for private interests to
What is Eversource trying to deliver more transmission to Boston area?
It's
Oh,
really
that's
in a
right.
little
Did
bit
I
of
see
seacoast area, which is the Portsmouth, everything around Portsmouth, Durham, Whitbridge is adds a reliability. It's to provide another loop, kind of like what Belco has been doing over time to kind of provide, backup in case one line serving IBM goes down. What was it called? The East Avenue Loop, Burlington is designed to provide a more robust delivery system. I think it's both reliability
Encourage people to
and
come
also
forward, otherwise that could just become public
region
and people
has grown so dramatically. They need a more robust capacity. So the upgrade requires a 46 kV line to 150. And they're going underwater. I've never spent so much time dealing with something
One of
called
the actual,
concrete mattress.
in terms
I
of
bet you don't know that before.
East Coast
So
saying,
where they go
case of
in
that.
under the bay, it's called Little Bay, which is under the Great Bay, which is then connected to the ocean.
I don't even remember
Where
what
they
they
go
go
under at the shorelines, they have to cover the line with a concrete.
It's a job, so he was looking for some sort of similar to that, like, criminal record request. He was looking
There's
for
a light
some
poured on
information
top,
from the,
like your fence at night.
They
wasn't
get
getting
precast.
and then he explained the whole thing with the first
And
video.
so at low tide, as you can see, some concrete going up under the shore. And a few, one or two residents who live right next to it. They're a little bit of a tizzy over that, but certainly.
What is the existing shore condition? Is it sand or is it?
It's tidal flats and muck.
Internet this year.
So,
Yeah, so I had the great pleasure of having to last summer kayak out on the bay for a whole day. But I ended up starting, they wanted me to start at low tide. And I could have gone like 5 miles south as long. I'll meet you down there, okay? So I ended up putting out in low tide and then I saw the water about 100 yards offshore. Turned out
Yeah, like, it's like,
just go miles out to the shores.
oh my gosh, in the muck.
I couldn't get out. I had to try to get out as quick as I could. So that was just like, I get paid to just have some fun, leave the job paddle and just do that.
and she's like,
This
we're not
past
friends anymore. Never mind.
Saturday, my wife went kayak and you know where Ethan Allen Homestead is. Went in there, out up all the way to the end. And then we lived pretty much in the mountains. We kind of down to the, nice day for it.
Yeah. When did you do that?
Saturday, this past Saturday.
Yeah, we paddled, my wife and I paddled. Sunday. About 6 miles up the road.
Oh yeah, that's the low water conditions where when you comes in, there's all those, it's like a blue lane in the sand, there's all these sand islands. Yeah.
So to pull up there.
Yeah, we sat a little bit, had a little cooler,
Yeah.
sat on the sand.
Life is good.
Yeah.
It's good. Where we were, it was obviously warm enough, and we put that.
Yeah, I did too.
Water.
I'm like, I want to be like, there's 4 pages, but I was like, no, this is, yeah.
Yeah, we saw a beaver that was territorial towards us.
Oh, really? Slapped us.
Yeah, charged us in the water.
No shoot.
And then I turned around and we saw a fox.
Okay.
Great blue heron.
Yeah.
Started to be exciting.
So we paddled to this state.
Okay.
It's been 5, 6 years. That's the juvenile. You can see them up there.
There's a flat tire on the deal that you have.
But you're here and you're okay.
I made it.
Let me say, I'm gonna let you, I'm gonna ask you to let me know when you're ready.
Okay.
I'm not forcing the issue.
David, I think you could go on up and, it's a, David has four typo, changes to make.
Okay.
We can do that on the record.
Are they in the report or in this
They're
testimony?
in the report.
Okay.
And aside from that, that's the only thing that you don't know about. Okay, we're ready when you are.
Ready.
Great. Good morning, everyone. This is the day 2 of the hearing in case number 17-5024-PET. We're here for additional testimony and cross-examination. The parties that were present in the hearing on yesterday are again present. And I see that Mr. Raphael is on the stand. If you could identify the witness, please.
Sure, if you could state your name and where you work for the record.
Yes, my name is David Raphael. I work at Landworks in Middlebury, Vermont.
Mr. Raphael, if you could raise your right hand and back to know that you swear and affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
I do.
Mr. Raphael, your aesthetics report has been admitted into evidence on the report dated June 19, 2018. Do you have any corrections to this report?
Yes, I have 4 typographic corrections. The first is on page 13, in the first paragraph. I believe it's the second sentence at the end. Vermont 276 should read Vermont 279. On page 22, this is the last full sentence at the bottom of page 222 before the bullet points. There's a parentheses that says page 49. It should be page 45. On page 30, last paragraph, the word, second to last sentence, I think it is, no, third to last sentence, it's changes is misspelled. I'm going to blame it on Word, but it should not have the N and the M before the A, so it should read changes. And then on page 33, last sentence ending in a colon, It should read regional plan, so it's missing a P and a space.
Thank you. And are those all the corrections you have?
To the best of my knowledge, yes.
Thank you. And the witness is available for cross-examination.
Thank you. Mr. Raphael, can you please turn to page 8 of your report under section 21B?
Yes.
You say that the size and scale of the project is compatible with its surroundings on a regional scale, correct?
Correct.
And you go on to say that it's, given its lower, I'm sorry, I'm going to page 10. Page 10, under section 21C, last sentence in the first paragraph.
Yes.
Given its lower height and its placement within the topography, the project will also not be skylined from any potential vantage point, so it will be absorbed better into the background of the adjacent vegetation, topography, and hills, correct?
Correct.
And I asked you this during your deposition, you felt that the colors and materials are suitable for the project?
Yes, for the most part. I would add, though, that in winter, with snow on the ground, there's no question that the project and the array will stand out more prominently.
Okay, but you did say that black is a suitable color. You said black fencing blends well into the background elements, correct? On page 10, second to the last sentence?
I don't think I said black.
You say typically black
Oh,
fencing
yes. Where's
blends.
that?
It's the second.
Oh, the last sentence, I'm sorry.
Second to the last sentence. Typically, black fencing
Yes.
blends well into the background elements and is a suitable color and material.
Correct.
Okay.
That's right.
And going to page 20 of your report.
It's an iPhone.
Someone else's microphone on?
That's an iPhone. Someone's iPhone's close to a microphone.
I'm sorry, what page?
I'm now on page 20.
Yes.
Sorry, it's page 19. Page 19, under your second step of completion analysis regarding clear community standard, section 2.2A. The second paragraph, not the quoted area, but the second paragraph in the second sentence, you say that a review of the 2010 Bennington Town Plan, the 2004 Town of Bennington Scenic Resource Inventory, the 2009 Bennington Park and Open Space Plan, and the 2007 Bennington County Regional Plan yields the conclusion that the project will not violate a clear community standard intended to preserve the aesthetics or scenic beauty of the area in accordance with the Queechee test, correct?
I said that then. My conclusions have changed with regard to that. Since this was written in June, and subsequent site visits and information that's been available to me makes me feel as though it gave me the sense that with regard to one aspect of Bennington's plan documents and standards, that this project is at a threshold of violating a community standard with regard to the gateway delineation and designation.
You're talking about the scenic resources inventory?
Yes.
That document hasn't changed since you did your initial review of this project or the initial site visits that you conducted, correct?
That has not changed, no.
Okay.
But my opinion has.
Your opinion has changed that that document contains a clear community standard?
On subsequent review of the document and a closer read on discussions and testimony submitted by the town and subsequent site visits have highlighted the presence and importance of the gateway.
You, and the gateway that you're referring to is Route 7 coming from the north, descending towards the project, is that correct?
That is correct.
And I think in your deposition, you said that you thought that the beginning of that gateway was about a half a mile north of the project?
That sounds about right, yes.
Okay. I'm going to refer you back to page 8 of your testimony.
In my report?
Yeah, I'm sorry, your report. I don't think your testimony has testimony. So, and again, the second paragraph, section 2(1)(b), second sentence, you note that the project is bounded on the south and west by US Route 7 and 279 interchange, the Welcome Center, and mixed residential and commercial and industrial beyond. It's a busy, high-density area with lots of traffic, commerce, and day-to-day activity. There will be very limited visibility of the project from these areas and not likely noticeable given the activities that will occur here. That's what you wrote in your report about the visibility from the Route 7 interchange, correct?
Yeah, I mean, I think I was referring, generally speaking, to the residential, commercial, industrial portions of the surrounding land use and landscape.
You're not talking about the project site in any way. You note that from Route 7 there will be very limited visibility.
That's a general statement with regard to the area identified, the areas identified in that sentence, not just Route 7.
Okay, okay. And you just stated that your opinion had changed with regard to the scenic resources inventory. Whether or not that was a clear community standard, but it's true that your opinion has not changed, that the project does not violate a clear community standard, correct?
I think there is a risk that this project will indeed violate that community standard and undermine the gateway area.
All right, we're going to come back to that. Do you remember from your deposition, do you recall that you had this discussion during your deposition?
I do.
You did, and I think you pointed out in your report that the scenic resources inventory doesn't mention the project site.
No.
And the views from Route 7 are the panoramic views that are addressed in the scenic resources inventory are towards the monument, correct?
Yeah, generally speaking, clearly as you come down, it's a very broad view. It is towards the monument, but it encompasses, 180 degrees or more as you come down the highway. You're certainly aware of the forested edge on the eastern side, and conditions on the western side. So it's not a static view, and it includes many different elements and characteristics.
You say on page 20, say on page, I'm sorry, 21 at the bottom, last paragraph. You're discussing the Rural Conservation District standards,
Yes.
and you quote from page 26 further above, and we had a long discussion about this yesterday. The development in this area cannot be sited in a prominently visible location on hillsides or ridgelines, and shall utilize earth tone colors and non-reflective materials on exterior surfaces of all structures, and must minimize clearing on the natural vegetation. You see where you quoted that?
Yes.
And then at the last paragraph of that page, you say that the intent of the recommendations of the standard of the RCD are clear, but then you go on to state that they do not explicitly exclude or prohibit solar development, correct? That's at the very bottom of page 21.
That's correct.
And I think you also say that the standards don't define what it means to be a hillside or to have a level of significant prominence. True?
Could you point me to that reference?
It's halfway through the last paragraph. The hillside does not rise to the
Oh.
level of significant prominence. And then you go on to note that the plan does not specifically identify the project area as a prominently visible hillside or ridgeline, correct?
Yes.
Okay. Thank you. Page 23, you discuss the scenic resources inventory in a little bit more detail.
Sorry, what page?
Page 23,
Yes.
and I'm looking at the last paragraph. You concluded there that the intent of the scenic resources inventory is distinct. You note that in the second sentence that there are many illustrative photos of pretty views along roads and across, going on to page 24, across meadows, but the project area is not specifically identified on the scenic resources overview map, and there is no list that distinctly calls out the project site. Moreover, there are no specific goals or policies that would specifically apply to the project or standards that detail how the project should be developed to meet those goals or policies. So you conclude there that it does not violate a specific community standard outlined in the scenic resources inventory. That's the last sentence of that first paragraph on page 24.
That's correct. But as I said earlier, upon, your opinion and your sense of a project, the more time you spend with it evolves. And I think while I will not say here that, the ultimate conclusion changes here, I would say, I'm not retracting the conclusion in that sense, except to say, I believe that this is at a threshold, and that upon further review and consideration of the gateway area, even though it does not specifically identify this site, that would not necessarily be the nature of a gateway identification. You would generalize the area of the gateway, and you wouldn't necessarily identify every single parcel or every single site within that, but I now certainly, and I think there has been testimony to this effect, that this project is part of that area, and as such, should be considered within the parameters of those standards. Having said that, it is true that no specificity has been provided with regard to this site in particular, but I think there are some general considerations and issues that emerge that warrant serious consideration, and where that leads me in part is to the final step of the PUC project, which is the mitigation measures,
Okay,
and
we'll get there in a
the
minute.
critical nature of addressing those mitigation measures to resolve the potential impacts and conflict with the community standard if this project is built.
All right, well, you kind of jumped ahead of yourself there. I was asking about a clear community standard and whether one had been violated, and you're not retracting your report and opinions in your report that there are no specific goals or policies that would specifically apply to the project, correct?
Within the scenic resource inventory,
Right,
yeah.
okay. And nor are there specific standards that detail how the project should be developed to meet any goals or policies to the extent they existed. So you said there are no policies or goals with respect to this project site, and there are no standards that apply with respect to this project site, correct?
Correct.
Okay. Let me bring you back to page 13. No, I'm on page 13. This section 2.1E, you talk about where the project may be visible from, right? And your conclusion was that a site reconnaissance conducted by landworks in the area along the roads near the site yield the conclusion that there is limited to no visibility of the project from major public vantage points. Now, and then you go on to describe the portions that may be minimally visible from the Welcome Center, US 7, or Route 279. I believe you just corrected that, 276, correct?
Correct.
All right, so, and that has not changed. I asked you about this in your deposition. These views from these locations have not changed.
Correct.
Okay. Let's turn to your orderly development discussion, which I think starts at page 30.
Yes.
Well, I guess before we go there, let me ask you a question about, I'll come back to innovation. Let's look at orderly development first. You note the section 248B1 statutory standard, you quote a portion of it on page 30, about halfway down the page. There are several instances, though, in your orderly development discussion, and that standard is will not unduly interfere with the orderly development of the region with due consideration having been given to the recommendations of the municipal and regional planning commissions, the recommendations of the municipal legislative bodies, and land conservation measures contained in the plan of any affected municipality. And you quote from that, and that is the standard. You're familiar with the statutory standard?
Yes.
And you've applied it numerous times in other cases where you analyze projects and prepared aesthetic assessments of solar projects as well as wind projects, correct?
Correct.
Okay. On page, I think it's on page 31. Let me ask you this. It's the section 248B1 standard is not a conformance standard, correct? There's no requirement like there is in Act 250 to conform to the regional or municipal plan.
No, I mean, again, going back to the quote, it's the reference is due consideration.
Right.
It's not conforming.
So it's not consistency with or compliance with any standards in the municipal plan, correct?
Well, correct. I mean, however, you would certainly want to address whether those standards or those narratives and the intent in the town plan either supports the fact that it does not interfere or does not support the fact that it does not interfere.
I gave you some documents, some of which were in the record. There's also two court decisions in the documents that I provided you. So these are not cross-examination exhibits, but you have a copy, and I have copies for the hearing officer. I apologize. One of these decisions came up yesterday. It's the In Ray Rutland Renewable Energy.
I'm sorry, Kim, could you give us a copy of those?
Yeah, I've just been handed by council a list of what's marked as a list of cross exhibits.
Yeah, I apologize.
And they include.
Those are cross documents. They're
So
not
these
exhibits.
are items that are already in evidence.
These are items, except for the court decisions. Rutland Renewable Energy came up yesterday. I brought a copy because I am going to question the witness on Rutland Renewable Energy, but I.
And in Ray O'Neill, for example. So
Yes.
these two.
May I have a copy, please?
I don't have any more of, I think you had the Rutland Renewable Energy decision.
What do you mean
I've given you the.
I had it? What do you mean? Is that in the cross-examination exhibit you gave me when you got here?
The Rutland Renewable Energy case is not going to be offered as a cross-examination exhibit.
Okay, but you're giving it to everybody else. Please give me a copy.
Okay, you had it yesterday.
I don't know what you mean by that. I
You
didn't have it yesterday.
You didn't have the case in front of you when you were questioning the witness?
No.
I will note that yesterday, many of our witnesses were cross-examined and given things as they were standing up there, or not provided the material, but you don't have that.
All of our exhibits from yesterday were provided to you, and you were given that opportunity to look through the few poster boards that we had. Everything else was record evidence.
I don't want to believe that. Are you familiar with the Rutland Renewable Energy decision, the Supreme Court decision? It should be at the top, I think, of the documents for cross-examination. And what I've done, it's a copy of the decision.
I am not familiar with this one, to be honest with you, in any detail. I recall the Cold River project. I do not know the particulars.
Were you aware that this decision was issued by the Supreme Court after the Public Utility Commission's original decision in docket 8302?
No.
Okay. And so I'd like to refer you to page 35. So you didn't have this decision in mind when you wrote your orderly development discussion?
No. Page 35?
I'm sorry, it's page 17, it's paragraph 35.
Oh, I'm sorry.
I'm sorry to interrupt, I beg your pardon. I'm not understanding what you were talking about when you just said this has come out since the decision in the other docket on this Chelsea case. Is
Yes.
that what you're saying? Okay, thank you.
I think there was a ruling from the hearing officer that noted that. Paragraph 35 on page 17 is part of Justice Robinson's concurring opinion in that decision. And she's talking about the due consideration standard. Do you see that?
I do see a reference at the bottom to substantial deference, and at the top, that mere consideration. So, and then above it, I do see that there is a discussion about due consideration.
Right, in paragraph 33, it says, although the statute calls for due consideration of municipal recommendations, it does not purport to describe what consideration is due. And the last sentence, it states instead, its admonition to the board must afford the town standards due consideration is reminiscent of the phrase, with all due respect, which invariably precedes and qualifies a statement evincing little or no respect at all, correct?
I see that, yes.
And the opinion goes on to compare other instances where the legislature required an agency to defer completely or conditionally to judgment of another body, right? And in
Objection. I mean, who's testifying here? This gentleman has testified he's not familiar with the thing. If we want to give him a chance to read the opinion and then come and answer questions.
I'm sorry.
Ms. Hayden, I want to hear her objection first.
First of all, we're talking about a concurring opinion, which means I came to the same result but for different reasons. So there's no precedential value, and this is not a lawyer, and this is not a legal analysis situation. I think it's unfair to sit here and testify.
So the basis of your objection is unfairness?
Is this, there's not even a question, and it is outside the scope of what this gentleman's opinion was based upon. He said this particular decision is not something that he was familiar with.
I'm going to allow her to continue. Overrule.
If you turn to page 18, Mr. Raphael,
Yes.
halfway through that paragraph, it's paragraph 35 of the opinion, but at page 18, there's a discussion near the end regarding an Act 250 permit. An Act 250 permit may not be issued unless the project is in conformance with the duly adopted local or regional plan. And the court goes on to say that the legislature has not included in section 248 any language suggesting that the board must afford any deference to town recommendations. Did you see that?
I do see that.
Okay. Your report begins on page 30 with a description of the standard and then explains what that means. And I'm just curious why it is that you were not aware, this is a 2016 decision of the Supreme Court that specifically addresses how section 248B1 should be interpreted and applied by the Public Utility Commission, and in particular, in a solar siting case, why it is that you were not familiar with this decision.
The easy answer is that at any given time in my office, I have upwards of 20 to 30 different projects where I am involved in developing testimony, review, and reports. I could not keep track of either the decisions of the Supreme Court, and for that matter, all the cases before the Public Utilities Commission. I mean, obviously, if they're brought to my attention, I would review and consider them, but this was not one that was brought to my attention, without really reading this whole decision, I really don't feel I can comment substantively on it, to be honest with you. However, I would say, just looking down in the next section on 36, it does say the statute requires that the board consider and perhaps even address the town's recommendations as to the effect of the project on development in the region. However, and I would, I think, to say why wasn't I aware of this, volumes of information and decisions come out of the state government and the PUC, and I can't possibly be aware or review all of those decisions.
And if I may, and to the extent that Ms. Hayden wants to argue that some analysis may be contrary to, again, a concurring opinion that the legislature did take action after this case. Mr. Raphael has said that he was not familiar with the case. I'm wondering if this is more appropriate for your briefing rather than, or to ask him specifically what you think.
No, I established what I wanted to establish, which was that he was not familiar with the controlling case.
Objection.
I'm sorry,
controlling
I'm
case,
not
come
sure
on.
why my cross-examination today is being interrupted in multiple instances when yesterday we had decisions
All right, okay.
being
Do we need to
addressed.
take time out?
No.
Okay. I think that the
I'm
question as to why he didn't know about the decision is irrelevant. The fact is, he didn't apply it, and he's testified to that.
Right,
Do you have any further questions with regard to this decision?
I don't.
Very well, move on.
Can you please look at what's been marked as Exhibit DPS 1? Okay, so this is an October 24, 2012 letter that you wrote to Governor Shumlin and Commissioner Miller,
Yes,
correct?
yes.
And this was signed by you, so you can authenticate this document,
Yes,
okay? And the subject was concerning the governor's energy generation siting policy commission, right?
correct.
Page 2,
I'm sorry, Mr. Mann, I'm having a hard time. Could you give me the number of that exhibit again, please?
it's exhibit, this is a cross exhibit, exhibit
Okay,
CS cross DPS-1, it's,
okay, got it. I was looking in the wrong place. Thank
there's
you.
an exhibit list on the front, just to help you locate documents. This is the very first one.
So this is something that's been marked for, but is not in evidence?
That's right.
Okay. You may proceed, I'm sorry.
Page 2. You provide the governor and Commissioner Miller with a number of key considerations regarding siting of energy projects, correct?
Correct.
And the second bullet, can you just read that into the record?
Beginning with the need.
The second bullet is concerns.
Oh, I'm sorry. Forgive me. Concerns with regard to the requirement of town approval for an energy project to go forward. It strikes me that this is the very reason these decisions are rightfully in the province of the state regulatory body. Most towns, when given the opportunity, will listen to the vocal and passionate opposition that exists for almost every proposed project and will not support the implementation of such projects. I would wager that the NRP would never have been built, for example, if individual towns had veto power. There does need to be, however, a viable and meaningful participation opportunity for towns.
Okay. And did were you part of the solar siting commission?
I attended several meetings and I provided testimony and documents to that committee.
Okay, and but the intent of this letter was to influence the siting policy commission as far as what they should or shouldn't do with respect to legislative initiatives?
It was sharing, I wouldn't characterize it quite that way.
Okay.
I believe it was sharing my experience and perspective, having been involved with these types of projects for almost 30 years now. Also, and importantly, the perspective of somebody who's also been a long-time planning commissioner and chair and development review board member and chair, regional planning commission member, and so it's really a sort of a broader perspective view, sharing some thoughts and perspectives, and yes, some suggestions as to things that should be considered going forward in this process.
You also, in the fifth bullet down, talk about the value of an impartial presentation and understanding of the actual impacts, correct?
Correct.
And you say that you refer to the actual impacts of wind, solar, biomass, hydro, and transmission projects. You go on to say there's so much hyperbole and unsubstantiated information about impacts that we truly need to establish an objective baseline. What hyperbole are you referring to?
I think that's a general comment that is certainly, I would say, more characterized, frankly, from my experience with wind than with solar. But, I think people become very passionate on both sides of the table with these types of projects. And in some instances, certain potential impacts or facts may be perhaps a bit overblown or misconstrued, and I've certainly seen that in some cases, and I think that's what that was trying to simply speak to.
Okay. You concluded in your orderly development discussion in your report that that the project would have unduly interfere with orderly development of the region. But I want to bring you back to your aesthetics analysis of compatibility that appears on page 8, section 2.1b. And we talked about this already, but you say the size and scale of the Chelsea project is compatible with its surroundings on a regional scale. That's the only location, do you see that? Okay, and that's still your testimony, that hasn't changed.
It is in reference to the specific design components of the project. So that's only one, criterion among many in the first step of the PUC analysis.
I understand, but you said that the size and scale of the project is compatible with its surroundings on a regional scale. That you didn't
With regard to the aesthetic considerations and components of the project itself, the materials and the elements, the array, and so forth.
Size and scale. What was the purpose of including the size and scale in that sentence? If it didn't
Again, the important word there is regional, because along in terms of the region, if you step back, it doesn't necessarily rise to a level at that scale of being incompatible. But when you look at the immediate environs and surrounds and the area of the town that will be impacted by this project, along with the gateway, there are some elements of it that will be ultimately incompatible with regard to the criteria that you would consider under orderly development. So there's a distinction there I want to make between the orderly development analysis and the aesthetic analysis.
Okay, so you think, even though do you agree that the project does not unduly interfere with orderly development of the region?
Well, we're going to mince words here, but let's go back to the statute, as you had me acknowledge previously. Let me get to that section here, if I may. The statute says orderly development of the region, correct. But in looking at the region, you also have to look at the host community and the town itself, which is an intrinsic part of the region. And in that regard, there's a difference in terms of how the fit might look overall in the region versus how the fit and compatibility with orderly development works within the municipality.
I'm going to bring you back to the Anne Ray Rutland Renewable Energy decision.
Okay.
Page 5, paragraph 9.
The Supreme Court decision?
The Supreme Court decision, yes. And if you need time to read, it's that paragraph I'm going to ask you some questions.
Which paragraph again?
Paragraph 9. emphasizes that the statutory requirement in section 248B1 relates to the orderly development of the region and not to a particular municipality within the region, correct?
Correct.
Were you aware that the court, when they issued this decision, were you aware of their interpretation that this is the standard, it's focused on the region and not a particular municipality? And I should say, were you aware at the time you wrote your report?
I was not, but I don't read that quite the same way you read it and interpret it. I think that while it says the statute relates to the region and not a particular municipality within the region, it does not go on to say that a particular municipality is part of the region. And so if this project affects that particular municipality as an integral part of that region, I believe it has to be considered. And in this region, the only place where this, where larger scale or ongoing and dynamic development substantially exists is in Bennington. And so as Bennington goes in this regard, so goes the region, and I don't think you can separate the two. And I don't believe there is, in this particular section, any specificity with regard to that understanding or that consideration.
Okay, that's fine. Were you aware that the Bennington Regional Planning Energy Committee had filed comments on this Chelsea Solar project? Or, I'm sorry, let me rephrase that. Were you aware that the Bennington Regional Energy Committee had provided comments regarding the Chelsea Solar project in this case?
I think I was aware, perhaps. I don't recall what that was.
In the, you should have in the list of documents of existing exhibits, what was marked as Exhibit CS-BW 13. It's a two-page.
Okay.
It's number 13, the Brad Wilson.
Comments of Bennington Regional Energy Committee.
It's number 13, the Brad Wilson. 13.
Comments of Bennington Regional Energy Committee.
It's not across 13. This is an existing exhibit. It's Brad Wilson's Exhibit 13. That's why it's in the yeah, I separated cross exhibits from existing exhibits and provided them just so you have them.
So I'm confused. Where is that?
You're looking at cross exhibits. This is in the other pile of documents.
DPS 13, Raphael Supplemental PFD Renewable Generation.
That's a cross exhibit. May I approach the witness?
Sure.
Is that okay? These are the.
Oh, I'm sorry. I'm looking in the wrong file.
Yeah.
Forgive me.
That's okay.
Here's the first one.
First. I don't see it in here. I see the Bennington Regional Energy Plan. Is it tacked onto that?
No.
It's not in here.
I can give you one.
Thank you. Oh, it's in there? It's in the Regional Energy Plan?
No.
That's CSBW 13.
Yeah, but it doesn't have the,
Oh, it's a sub-element.
oh, it's in the back?
It's in the back.
Oh, okay, forgive me.
I'm sorry, I gave you the wrong one. It's this one.
No, I think I've got it here then.
No, it's not. It's
Yes, it is. 13 is a.
Yeah,
It's a one page.
it's not in here, yeah, okay. Would you like me to read it? I mean, you have a chance to review it, or?
I want to kind of move things on, but this is it's an email from Jim Sullivan, from the Regional Planning Commission to Brad Wilson, the project developer. Do you see that?
Yeah. Oh, yes, I'm sorry, forgive me, yes, I do see that, and I'm on 2, which is Chelsea Solar, yes.
Did you, is this the first time that you've seen this document?
I do recall it, but I have forgotten about it. I mean, if I may, can I read it briefly, or? Thank you.
Okay, you just read it. Have you read this previously?
Again, I have a vague recollection, but I can't pull it out specifically. But.
The statutory standards requires due consideration to recommendations of the Regional Planning Commission, correct?
Correct.
What consideration, what recommendations of the Regional Planning Commission did you rely on, or what Regional Planning Commission recommendations were you aware of when you wrote your report in this case?
I relied on the regional plan.
So you did not, you did say in your testimony, I believe, and it might have been in your deposition, that you consulted, you spoke with people in the town officials, correct?
Correct.
That informed your opinion quite a bit, correct?
It was one, I wouldn't say quite a bit, it was one source of information that was factored in. And yeah, I mean, it certainly informed my thinking process. I wouldn't say quite a bit, but it was part of it.
So the fact that the Regional Planning Commission provided a specific recommendation with respect to this project, these exhibits were entered last November, you didn't think it was important to review that detail before making your opinion in this case?
Well, again, as I said, I think I did maybe see this. I was left, and I'm reading it now again, that I was left without a clear sense of exactly where the Energy Committee stood on this, other than to, at the end it sort of says, that they're not changing their original opinion, but the committee recommended the recommendation that the BCRC's comments on the first project be carried forward to the new project, with a note that the additional screening is being provided. Yeah, I think this is certainly a piece of information that is part of that. It has certainly been provided by the Energy Committee, and is one, again, another potential factor. Yeah.
Okay.
But it's not substantive per se with regard, or speaks specifically with regard to orderly development, as far as I see it here.
Okay. would you agree with me that the project, which is approximately 9.4, I think, acres, is a small fraction of the total town of Bennington land area?
Yes.
Okay. And I think we discussed the rural conservation district in your deposition. We refer to map figure 3-2, which shows where all of the the district boundaries for the various zoning districts, do you recall that?
Yes.
And it's true, isn't it, that you agree with me that the rural conservation district makes up approximately 50% or half of the town?
That sounds right, yes.
Okay. So I'm going back to the cross-examination exhibits which have the yellow stickers on them. And Exhibit 2, what's been marked as Exhibit 2 is your response to a request to admit.
Yep.
And so you've admitted that the project site is not identified as a bright line, barrier, buffer, or land use boundary, correct? In the Bennington town plan?
Correct.
Okay. I'm going to, before I lose track, move to admit into the record Exhibit Chelsea Solar Cross DPS 1 and Exhibit Chelsea Solar Cross DPS 2.
Is there an objection?
No,
I think I would object to DPS, or cross DPS 1, the letter to the siting council. There was testimony elicited, but I haven't even had a chance to read the whole exhibit, and I'm not sure why the exhibit would be introduced when this gentleman was just cross-examined on the contents of it. It was read, she asked him to read the second
Do
bullet.
you have a foundational basis or concern with this document?
Yeah, I haven't even had a chance to read the whole thing, and we've talked about one paragraph of the document, so why would you put the whole document in?
Okay, let's take a 10-minute break and give you that opportunity. We'll come back at 15 minutes before the hour.
I'll be back.
Serving refreshments.
I'm going to say something before we go back on the record. I don't want to be recorded. Especially secretly.
Well, I don't know, there's an outlet right here, I just can't, I don't know, I guess. I know John, I can just go.
Can you touch on?
How are you? Good.
They came and did a presentation.
They came in and met with us. I mean, with Billy, actually this morning, I couldn't be there, I was here, but, I think they're getting close to thinking about next week.
Okay, yeah, they told us they were trying to come in September, but I was, people aren't gonna file.
Yeah, they've been chomping at that one for a while.
Yeah.
It's a non-substantial change.
Are we treating it?
It's crazy.
Are they not?
And so I think they acknowledge that they actually need to.
Yeah.
So I think that's what we're doing for something you probably be interested in.
Yeah, definitely.
Right?
Yeah. These are AG's office, legal insurance.
Great.
Yeah.
Oh, okay. Nice.
Jeff.
Oh, Chris.
Yeah.
I think you were here yesterday.
I was not, no.
You were not?
No.
Okay.
You did that.
I told her that I'd be interested to watch, so.
But I might just get that
It's like,
Oh.
yeah, yeah.
I'm hoping for a next.
Yeah.
Definitely.
Well,
What'd you do, Kim?
oh, I just rolled my foot.
Blaring. Something.
I know.
Yeah. Yeah, what to say.
The exhibit being in it.
So what has previously been marked as Exhibit CS dash cross dash DPS dash 1 is a bit.
So I was asked to have the microphone closer to me, but it seems to have, I'm gonna do that.
Okay.
Can you hear me?
Just do your best Shakespearean.
Have you, in reviewing the Rural Conservation District, I'll just call them standards, have you evaluated whether other commercial solar projects have been cited within the Rural Conservation District?
Evaluated?
Yes.
What do you mean by evaluated?
I mean, have you looked at any PUC filings, town documents, some of the exhibits that the petitioner filed that addressed other commercial solar projects in the town of Bennington and the Rural Conservation District?
I'm aware of references to other projects that the applicant has filed and pointed out in the site visit. Yes.
So
I wouldn't say I've evaluated it.
Well, and that's a question I have. Why is it that you would not look to see how the town addressed other commercial solar projects in the Rural Conservation District?
Well, I mean, I looked at the fact that, I was aware of the fact that there were other projects in the Rural Conservation District, noted that almost to a one, they were of a different size and scale, and in very different locations. You know, typically, the focus in a project review isn't on other projects. It's really on this project that we are charged to evaluate and review for its specifics and its conformity and its characteristics. So one decision made about one project may or may not have any bearing on another project necessarily.
You mentioned, so what are the two other projects, or you mentioned several other, which ones are you talking about?
I don't know them by heart, but I think...
By reference to location?
I mean, again, we drove by one at the site visit, I think that we were all at earlier this summer, earlier. I'm not familiar with the specific projects.
Are you familiar with where the E.R. Bennington Solar Project is, which is Route 7 near the police?
No.
You didn't review that?
No.
Okay.
No, that was not my charge. It's not my charge to review those projects. My private charge was to review this project.
But you didn't consider how the town's position with respect to other solar development in a rural conservation district and how that may impact the town's view as to orderly development. You don't think that that's a relevant inquiry to see how other like projects have been considered by the town with respect to orderly development?
I mean, it certainly could be considered. I don't know as if, there may be some relevance, I would grant you that, but again, you really have to look at each project individually. In my experience, for example, as someone who is on a development review board that has reviewed projects in my own town in the same district, decisions we make on one project may not have any applicability whatsoever to another project because there are very distinct characteristics, including, most importantly, the site and the location.
Is proximity to Route 7, should that be a consideration for the Route 7 solar project?
In what regard?
If it's very visible from Route 7, is that something that should be considered as you're evaluating whether it's consistent with orderly development of the region?
Visibility is not a specific criterion with regard to orderly development per se. And I think there's been I would leave it at that.
What about with respect to aesthetics?
Again, it's certainly in the sphere of things that would enter into your review with regard to the notion of fit and intactness and some of the Queechy standards that you could apply to land use planning considerations. But orderly development is a planning consideration, a development consideration, and not an aesthetic consideration per se, as far as I've interpreted it and I've seen it interpreted and considered in previous cases.
Let's go back to page 34.
34
of your report, I'm sorry. The first paragraph under the quoted language. Do you see where I'm referring?
Yes.
Second sentence, you make a statement that while the RCD does not preclude development, it is clear from the current town's sentiment and efforts in changing the town plan that the community and the neighbors do not envision a project such as this. And I want to ask you about the portion of that sentence where you say it is clear from the current sentiment and efforts in changing the town plan. Why is this relevant to your orderly development discussion, which you said was based primarily on your review of town plan documents?
It's another information point.
Isn't it true that your conclusions with respect to orderly development are largely driven by what you perceive as being the current town sentiment?
No.
If I could ask a quick question.
Sure.
Please.
Are you aware of the fact that the town no longer opposes this case? Does that change the nature of your opinion that you've articulated here on page 34?
No.
Was the reference to the current town sentiment in regard to changes made to the town plan in 2015 and 2016 and 2018? What current, were you referring to efforts, you said efforts in changing the town plan? Or are you referring to, you're not talking
Certainly
about...
that's referring to that, in part, that process, yes.
So you're referring to documents that are not relevant to this case. Are you aware that the hearing officer has issued a ruling on vested rights?
I am.
Okay. And so the plan that governs this proceeding is the 2010 town plan?
I understand.
Okay. And so why would sentiment regarding changing that plan and as it relates to the more current town plans be relevant?
I think it's relevant insofar as the review and consideration of solar projects, not just in Bennington, but throughout Vermont, is a work in progress. And communities are struggling in part to get their arms around the impacts and the changes that this rapid development of solar projects is creating in communities. And I know that, again, from my own experience in my own town. And I think you can't totally have blinders on about that process, and it's certainly something to be noted. And I think that was sort of the general reference intent there.
Okay. Your orderly development assessment does not discuss any renewable energy goals of the town or the region, isn't that correct?
That's correct.
Or did you evaluate? Do you need time to check that?
Yeah, I mean, I think, and frankly, again, this sort of, it comes up again and again and again, and that is that most Vermont towns and town plans now have sections, obviously, on renewable energy. And I think generally speaking, we as a state, as a municipality that we may be a member of, and even as a homeowner, are looking to ways to support and adopt renewable energy. But that's not a blanket, dictum that would overrule any other consideration, such as land development, land planning, aesthetics, things of that nature.
But you agree it's a relevant consideration when you're looking at orderly development that you consider the town as the town's expressions regarding renewable energy just generally?
I think it's implicit.
Okay, but you didn't address any renewable energy goals or anything from the town or the region in your report?
I did in my report address them.
Can you show me where that is?
In the aesthetic section, I believe there's some...
I'm talking about in the orderly development section.
Okay. Again, in the orderly development, energy goals and policies are, again, somewhat generalized. They don't necessarily attach to land planning specifics or dictums, as I said a moment ago. They talk about the need to generate energy and the desire to meet certain goals and the desire to support certain types of energy. but then the town plan and other elements of town planning processes, such as a scenic inventory, the open space plan, would perhaps support and further address or delineate the land planning and the locational aspects of that. But energy policies and plans generally talk about energy generation, the need for it, the need to meet certain goals, things of that nature, without, getting very specific about location. That is changing now with Act 174 and the ability of communities to connect within an overall energy plan of their town plan, sites that are appropriate and not appropriate and that type of thing. But energy plan, I don't think I need to read, although I did, the regional plan and the town plan is with regard to overall energy and general energy policy to make a determination with regard to orderly development specifically.
Let me refer you to pages 20 and 21 of your report. You quote two of the goals. Actually, I may have the wrong page here. I'm sorry, it's page 31. At the bottom, you quote the 2010 Bennington Town Plan. You quote two goals, goals 2 and 3.
Yes.
You're aware that there are 7 goals that are articulated in the Bennington Town Plan?
If you say I didn't know the exact number.
It can. Let's turn to the town plan at page 3, which it's 2010 town plan. Do we have that? It's not an exhibit. It would be.
You have whose testimony did that come under?
This, the label is Exhibit CSBW 81, Bennington Town Plan 2010 version.
Sorry, what
in the
page?
stack, it's not across exhibits.
Oh, yeah.
I'm sorry, what page, please?
Pages 2 and 3. So at section 1.2, it discusses the goals
Yes.
and recommended actions. The beginning of section 1.2, it states that specific goals provide focus and direction to the policy statements and recommended actions set forth in each chapter of the town plan. You see that?
Yes.
And it states that these goals are consistent with section 4302 of 24 VSA.
Yes.
And I asked you about this in your deposition. You're familiar with that 24 VSA section 4302 is the state land use planning law?
Yes.
So you were aware that there are specific goals that are required to be addressed in each town plan?
Yes.
Okay. So I turned you to your report where you cited to 2 goals. Your report at page 31 and 32, you cite to goals 2 and 3.
Right.
But there are 7 goals, with the 7th being to promote efficient use of energy and utilization of renewable energy resources.
Yes.
And again, I don't want to belabor this too much, but does the absence of it, were you aware that this was a stated goal?
Sure.
You were?
Yeah.
Okay.
As I said, just about every single town plan in the state of Vermont has this as a goal.
Okay. And at the beginning of the section 1.2, it states, and we've already read this, but these specific goals provide focus and direction to this policy statements and recommended actions in each chapter of the town plan, correct?
Right.
So the town plan energy chapter, which is I believe it's chapter 8, these goals are intended to provide focus and direction for that, correct?
Sure.
Okay. And equally, I guess, these goals and recommended actions also would provide focus and direction with respect to the land use planning chapter, which is chapter 3 of the town plan, correct?
Certainly.
Okay. So the energy chapter is near the end of the report. It begins at, I'm sorry, not the report, it's at the end of the town plan. It's beginning at page 92.
Yes.
Did you review this chapter prior to writing your report?
Yeah, I actually, this chapter, I did look at it, but this chapter was reviewed more in depth by another member of my staff.
Okay. Going to pages 95 and 96, energy policies and recommendations.
Yes.
Did you review these, they're numbered and then bulleted policies and recommendations with respect to energy?
I reviewed them, not in detail, but I did review them.
Did you consider the goal number 2, which is, or policy number 2, create and support programs and facilities that provide stable, affordable, and clean renewable energy sources of energy, including wood and other biomass, wind, water, hydroelectric, solar, and geothermal?
Again, as I said, yes, I mean, this is a staple in a section like this for most town plans to address and promote, in a general sense, the use of renewable energy.
Let me ask you this, as we walked through some of your other reports that you've provided in other cases like Kingdom Wind, isn't it true in other cases where you've provided an opinion in the form of a report regarding orderly development that you have articulated some of the renewable energy goals of the town or the region?
You know, typically those are done under the community standards review and aesthetics that you would certainly cite or mention that those goals exist, absolutely.
So your recollection is that you didn't do that in other cases with respect to orderly development?
Again, I'm not certain that, I'd have to go back to look at the reports. I mean, that is always in the background, and as I mentioned a moment ago, somewhat implicit that a community is striving to implement this type of energy generation, and so one understands that throughout a process of reviewing, these types of projects.
Okay. I've also given you a document that's currently in the record already, the Bennington Regional Energy Plan.
Yes.
Exhibit CS-BW80, you have that?
Yes, I do.
I don't believe you refer to this in your report either, correct?
No. Not under orderly development.
So I don't think we need to walk through this. I take it that this didn't inform your opinion on orderly development, the Bennington Regional Energy Plan.
Again, understand that regional planning commissions create energy plans, plan for energy, seek to site energy projects in appropriate locations. I did not need to necessarily cite it specifically or reference particular quotes to understand that as part of a consideration when you look at land use development.
But I don't think that was my I asked you whether, you said you hadn't read it.
No, I did say I had read, I looked at it, yes, I looked at this.
You looked at it.
Yeah.
So it did or did not inform your orderly development conclusions here?
I would say it did inform. I mean, again, as I've been trying to, explain, that, let me say it again, that it's implicit in most towns, if not all in Vermont, that, renewable energy is a desirable goal for that community. So don't necessarily need to, repeat it again and again, but it is part of, I understand that, applicants and developers are trying to locate, as well as towns, suitable locations for renewable energy development. And I think I don't always have to, write that or articulate that, to have that as part of my internal thinking and decision-making process in a project of this sort.
Would you characterize the town of Bennington's goals that we were just talking about, the seven goals, and in particular number 7 as being a recommendation of the town, as that term is used in section 248B1?
The recommendation, I think, in the orderly development statute, back to that, the recommendations of the municipal legislative bodies and the land conservation measures contained in the plan. So I think there is a general reference to town planning goals in that regard.
Including renewable energy?
Certainly.
Okay. And I'm going to refer you to the Bennington Municipal Energy Plan, Exhibit CSVW 88. It's a 2012 town plan.
Yes.
You have that?
Yes.
Did you review that before writing your report?
I think a member of my staff may have reviewed this. I do not specifically remember reviewing this. Again, it was not I'm not sure it was a document that was part of this docket. I may be wrong, but I think it was reviewed. I did not review this specifically.
So you made no inquiry as to whether or not the town of Bennington had an energy plan?
I knew Bennington had an energy plan. Again,
Okay.
Many communities do. So.
Okay. So I'm going to refer you to page 38.
Of which document?
This is the Bennington Municipal Energy Plan. Page 38, commercial renewable energy opportunities in Bennington. Were you aware that they had a plan document that addressed that issue?
I mean, I understand the community has addressed options and commercial renewable energy, yes.
Okay, but you hadn't looked at this. I think you said that, correct?
Correct.
So let me just ask you, because about whether you consider some of these things to be recommendations. The amount of money spent on energy in Bennington, as pointed out in previous sections, suggests that real economic benefits can be realized if some significant portion of that energy is generated from local sources. So, do you, in your opinion, is that a recommendation that within the meaning of section 248B1?
Certainly. Again, as I've been saying all along, it is understood that most communities are looking to support and develop in suitable locations, renewable energy opportunities.
Okay. And the town of Bennington is as well, correct?
Correct.
Page 43 of the plan talks about solar energy potential. I'm looking at the, so there's a sub-part of this plan that has the header, solar energy potential, on page 43, about halfway down. Do you see that?
Yes.
And several sentences in that first paragraph is the statement, given the huge amount of solar energy striking the Earth's surface, friends, the cumulative solar energy irradiating the Earth in a day is equal to the energy in billions of barrels of oil, and friends, there are compelling reasons to attempt to implement solar technologies wherever possible. And again, do you agree that this is a recommendation that should be considered within the meaning of Section 248B1?
Yes, and it's not new news. I mean, again, the key consideration there when it comes to land planning is wherever possible. Doesn't say everywhere. It doesn't say every opportunity, every site, every place within a district. It just says wherever possible.
Okay. Summary and recommendations, here's at page 44, under subpart Roman numeral 8. Do you see that?
Yes, I'm sorry. Yeah.
Okay. It begins with the statement that energy is fundamental to all aspects of our lives, and goes on in the third sentence to say, the information provided in this plan illustrates the staggering amount of energy that is used just in Bennington and the tremendous outlay of financial resources that such energy use entails. Is that something that you reviewed, the amount of energy used locally in Bennington?
No.
Okay. The municipal energy planning committee that created, the Bennington Planning Commission actually created this document, and in doing this, they looked at, on page 44, they looked at and evaluated how much money was being expended on energy, and they reference at the bottom of page 44, it's roughly $1 million per year. Do you see that?
Where's that?
At the bottom of page 44, they...
Oh, yes, I see. $15 million a year?
Yep.
Yep.
And the sentence before that, they note that a significant amount of energy expenditures are currently being exported from the local economy and would be available to be reinvested in the local economic activity if those expenditures were happening in Bennington rather than being made for energy imports out of state. Do you see that?
Yes.
The recommended actions under this municipal energy plan begins at page 45. There's a list of recommended actions.
Yes.
The first one that's listed there says the town should maintain and support its municipal energy committee. That committee should pursue implementation of this plan, advocate for energy conservation and renewable energy projects, and report on a regular basis to the select board. Let me ask you about that that first recommended action, were you aware that that was a recommended action of the town of Bennington?
Not that specifically, no.
Okay. Would you agree that that's a type of recommendation that should be considered under section 248B1?
Well, again, if it had specific elements relative to siting and land use and impacts on land and the context for the project, yes.
Okay. I want to switch gears here a little bit. To your aesthetics assessment of visibility, and I think that discussion happens at around page 11 of your report. I guess this is under a broader section. So this is your aesthetic, page 11. Maybe it's page 12, 2.1. I'm sorry, I'm giving you the wrong page. It's page 13. 2.1E is your discussion of where is the project visible from.
Yeah.
You don't mention, you talk about the limited visibility from a number of vantage points, but you don't mention the Southern Vermont College, correct?
Correct.
And that would you agree with me that the college is about 3 miles away?
That sounds right.
Okay. And you agree that the college would have limited visibility primarily because of the distance?
Yes.
Okay. Your report then goes on in talking about visibility to talk, on page 15, to talk about perception, and I just want to focus on that a little bit. My understanding from reading your report at pages 14 and 15 is that you're really addressing the Apple Hill neighborhood, is that right? You've got a photograph figure inlay that shows views from various parts of the Apple Hill neighborhood with arrows pointed at the projects.
No, actually, I think, as I read it again, I think the thinking there was, right now, and I think we saw this really quite nicely from the golf course, the gateway area and this site, provides, from that distance, which I think is about a mile maybe, or well, maybe I can't recall the that's right, provides a really good view of the intact, more or less undeveloped or very low density developed area that this project is part of, and that contributes substantially, I think, to the rural character and the overall sense that this is an undeveloped hillside that is part of a gateway into the town of Bennington. And from the golf course, you could see the project in its entirety. And I think that loss of that green space, that open space, that rural landscape to a project of this scale will be noticeable and will make a difference and will have a change.
So,
it will be substantial.
But you're not talking about the golf course on page 15, or are you now suggesting that the golf course is one of the areas that you were referencing on page 15?
It doesn't matter whether you're on the golf course or at the Welcome Center. That does not change.
Okay. I had a different line of questions really about how perception fits into Clichy. But let me ask you this, now that you've brought up the golf course. Your report doesn't mention it, correct?
Correct.
And you didn't supplement or amend your report to clarify what you just testified to, correct?
No.
Is there a reason for that?
I don't think it didn't occur to me to do that, I guess, but perhaps I should have.
Did you, you didn't create any simulations of what the views would look like from the golf course, correct?
No.
Okay.
Can I ask a question, because I'm a little bit confused about the language that's in 14 and 15 that you've highlighted. On page 14 at the bottom, it says the project will be directly visible from nearby residents, most of which are oriented towards the project in the direction to Mount Anthony. So is it your testimony now that this isn't about the visibility from the houses, this is the visibility of the houses from from Mount Anthony and the battle line?
I actually think it's both, frankly. I mean, I think it's specific visibility in the neighborhood and more widespread visibility overall.
So looking at the diagram that's on page 15, so this isn't a line of sight diagram to the projects. This is a line of sight, it's not even really a line of sight. It's sort of they look in this direction towards those things. So it's your testimony that you didn't do any line of sight assessment of the visibility of from neighbors' houses to the project?
No, I did not prepare that.
Okay, thanks.
Technical line of sight section. That's correct.
So your conclusion that it's directly visible isn't based on any kind of simulation going from those properties that are shown on page 15?
It's based on it's based on being on the site and seeing that on the site.
So again, you were looking from the site back to the properties?
Looking both from the driveway area and the extension of Apple Hill Road.
Okay, so in front of Ms. Harris's house?
In that area, yes.
You could see the project?
Yes.
Okay. Could you see it from any of these other houses? Did you make that assessment?
I did not, because I could not go into private properties, but looking at both topography and vegetation, it's my conclusion that at certain times of the year the project will be visible from those places.
Okay. Did you look at Mr. Kane's visual assessments?
Yes.
Because he makes a different conclusion. Having done the simulations and the visual assessments, he says that they aren't visible from anywhere. I'm looking at Exhibit CS, MK3, and MK2. MK3 are his figures that include the simulations, and MK2 is the report. So you didn't factor these documents into your statement on page 14 that they would be directly visible from nearby residences.
I actually reviewed that, and could I please just see that up for 1 second?
I'm giving you Exhibit CS MK3, which is the visual assessment figures prepared by Mr. Kane.
Yeah, I think, first of all, let me just say that I had a tremendous amount of difficulty looking at these simulations and relying on them, number one, because I don't think these are fully accurate simulations of actually what's out there. I mean, they use model trees. It's not the real trees that are there. And I think the other thing that was lacking in Mr. Kane's testimony, which is why I don't think it is totally reliable, is there's no real mention of the effects of the construction and seasonal views, and the fact that construction has impacts that no one, I don't think, in their right mind would predict to absolute specificity. And I have seen in a number of instances in Vermont where large clearings or project areas have been opened up, and the consequent degrading of surrounding vegetation that might or might not be relied on for screening, it can be and has been such that things that we thought weren't going to be seen now are being seen. So there's an element of unpredictability as to the short and or long-term impacts.
Which is why you made your mitigation recommendation.
Exactly.
I have a question. Just now.
Thank you.
So I was going to go to page 15 of your report. You make the statement there that there is a perception of rurality that is existing and expected. And then you go on with this discussion of perception to say that given the project will be visible from these adjacent properties and appear out of place in this distinct context, it can be concluded that while visibility alone will not be extreme, the effects on, quote, overall perception, comma, quote, sense of place, end quote, and, quote, quality of life of the area will be adverse. You see that?
Yes.
So you don't have a footnote that discusses why you're putting quotation marks around the overall perception, sense of place, and quality of life statements, but I went back to your general approach discussion at page 1 of your report, section 1.2, and noted that you used those very same terms on page 1. Do you see that in the paragraph under section 1.2?
Yes.
All right. In that portion of your report, you say that the PUC analysis provides a clear framework for evaluating whether the aesthetic impacts of a project are adverse and undue, and then you go on to say the former environmental board has defined aesthetics as involving, quote, overall perception, and, quote, the sense of place and the quality of life that a place affords, end quote, and you quote to, or reference to, a Vermont Environmental Board 1999 decision, correct?
Yes.
Okay, so I have a copy of that decision. That's the PUC decision. It's been marked as or not marked, it's been provided in a pile of documents that are not cross-examination documents because this is a court decision, or I'm sorry, an environmental board decision.
Okay.
So you'll see it's Vermont Environmental Board, Omnia Inc. on the cover page.
Yep.
Okay.
Got it.
And if you turn to page 22, finding 108, turn to page 22, 108,
Yes.
it discusses sense of place and quality of life. Is this the decision that you were quoting from at page 1 of your report and that you refer to at page 15?
I believe so. Yes.
Okay. I've looked at your other reports, and we're going to walk through them in a little bit, but I did not see a sense of place, quality of life, perception, discussion in your PUC analysis for any other reports. Do you know why? Can you explain to me why you've articulated it here?
Sure. So as this finding so aptly states, if I may, aesthetics involve, the concept of aesthetics encompasses more than just visual. Aesthetics involves all the senses, including sound, smell, and overall perception. Aesthetics involves a sense of a place and the quality of life that a place affords. The aesthetics of a Vermont village environment include all of the qualities that make it attractive and desirable to live in and visit. So this, has been, I think, in the background, as your own experts have so aptly demonstrated. They have completely focused on just visibility. They do not account for any other aspect of aesthetics. As my thinking and experience with these types of projects has evolved, I now recognize how important this is to communities, neighborhoods, and towns. And that was driven home to me so dramatically in the case of the Addison County Natural Gas Project, when one day the then Public Service Board had an occasion to meet with the residents of Cornwall out in a field where the gas pipeline was proposed for. And several members of Cornwall officials and residents made statements that I found to be absolutely compelling. And those statements really reinforce this notion that you don't have to see a project to be unsettled by it. You don't have to have visibility to find that a project is going to affect your sense of well-being, and to that extent your quality of life. And clearly, these people were deeply disturbed by the notion of an industrial, major gas pipeline running through their bucolic, pastoral, landscape. It was an absolutely beautiful day. And I think that was when the tide turned. And soon thereafter, Vermont Gas withdrew its proposal to extend the pipeline through that portion of Addison County. And that particular experience further reinforced my sense that we have to consider, as this particular note in this decision, all of the senses, including your sense of well-being and your sense of place.
Well, let's look at this footnote, or I'm sorry, this paragraph 108 or finding 108. This case involved an increase, a proposed increase by OMIA of 170 18-wheel, 22 or 24-ton pickup trucks per day, 6 days per week, beginning at 6 in the morning through the historic Brandon Village. Right?
Absolutely.
And have you read this entire decision?
I don't know if I've read the entire decision, but I'm familiar with it.
You're familiar with it.
This portion of it.
Yeah. The OMIA was denied its Act 250 permit. The environmental board at page 37 has quite a, and then on to page 38, has a long discussion about the fact that that project was shocking and offensive to the average person. Having that many trucks go through the town of Bennington, the historic village, 6 days a week, beginning at 6 a.m. in the morning, 170 large 22-wheel trucks was shocking and offensive, right?
Correct.
Okay, and that you understood those were the facts that were before the environmental board when they used the language that they were using in finding 108. They were addressing this high volume of truck traffic through the historic village.
It is true they were addressing the high volume of truck traffic going through the village. It is also true, as I read a moment ago, that they referenced aesthetics in a general sense and implied that it could consider this without any reference to a specific project. Yes, in this project, because of the impacts the truck traffic made, or potentially going to make, that was both a shocking and offensive determination, and then again that sense of place determination that weighed into that. So yes, it was specifically, the decision ultimately was addressing the specifics of that project. But I cite the other quote insofar as the board understood and articulated that any aesthetics review could take into account that understanding and definition of aesthetics, regardless of what the project type might be.
So you don't agree that the evaluation of perception and sense of place relates to the extent it relates at all, to the shocking and offensive portion of the Queechy test?
There is a relationship, certainly, but it's not, completely overlapping in that sense.
Okay. And you agree with me in this case, you found that the project is not shocking and offensive to the average person. You say that at page 25 of the report.
That's right.
Okay. Page 11, let's talk about open space. You begin section 2.1b with a definition of, your definition of open space. You say open space can be defined as any piece of land that is undeveloped, has no buildings or other built structures, and is accessible to the public or contributes to open space views accessible to the public. Correct?
Correct.
And do you have a basis for that definition? Is there a case that you didn't note here that you're relying on for the open space views accessible to the public?
I think that over time, that is how I, in my experience, certainly have come to view what open space means. There is no specific definition of open space with regard to this statute or statute, I don't believe Act 250 either. I am aware that there may be certain definitions of open space that say it is, landscapes that should be publicly accessible. However, I don't necessarily fully agree with that. Accessibility could be, visual, and sensual in other ways, and not just physical accessibility to that site.
Let me refer you to cross exhibits 5 and 6. We asked you some requests and discovery about the Parks and Open Space Plan, which you did not. So the Parks and Open Space Plan, which you did not reference in your open space discussion, right?
No.
Okay. But you're familiar with the Parks and Open Space Plan?
Yes.
So exhibits, I'm referring you to 2 pages. It's exhibit 5 and 6 from the exhibit cross-examination exhibit 6. It should be pretty close to the top.
Okay. This is from my discovery?
Yes.
Okay.
So there are 2 back-to-back exhibit across, 5 and across 6.
Yeah. Got it.
You admitted that the Parks and Open Space Plan for the town of Bennington at page 11 identifies which parcels the town considers open space, including conserved open space, correct?
Correct.
Okay. And you also admitted in Exhibit 6 that the Parks and Open Space Plan does not identify the project site as open space.
Correct, because again, for the purposes of Parks and Open Space Plan, they were looking at conserved open space and public park areas, and were not, I don't think, in that use of open space, which certainly is a valid use of it, looking at a broader, kind of more holistic definition of open space.
Okay. I did provide you with the park Well, maybe it's not really even necessary to walk through then the park and open space discussion, but I do have just a couple of questions, and I want to know if you considered this. The park and open space plan is exhibit CSBW 49. That is in the pile of documents to the left. It's an existing exhibit.
I don't have that in front of me.
Yeah, it should be there. It's
Okay,
exhibit
I'm
49.
sorry.
CSBW format?
Yeah.
Got so many things up here. Oh, here it is, I'm sorry.
No worries.
Forgive me, a lot of papers on my desk, on this desk.
So page 2 of the park and open space plan. Standards, what their approach was, correct? And
Yes, I'm sorry, excuse me.
that's okay. The second to the last sentence of that very first paragraph says that it is useful to compare Bennington's existing park and open space resources with established standards such as those promulgated by the National Recreation and Park Association, because other communities have used those standards as benchmarks. Do you see that?
I don't, where are you again? I'm sorry, what?
Yeah, the top of page 2, the park,
Middle of the first paragraph.
in the very first
Oh,
paragraph.
yes, I'm sorry, thank you, yeah.
So they're referring to the NRPA, or National Recreation and Park Association. Which was prepared by the Bennington Planning Commission. It's a 2010.
I'm sorry, what?
Yeah, the top of page 2, the park,
Middle of the first paragraph.
in the very first
Oh,
paragraph.
yes, I'm sorry, thank you, yeah.
So they're referring to the NRPA, or National Recreation and Park Association standards as kind of a benchmark for what Bennington maybe should be comparing their open space and park designated areas, right?
Right.
And then on page 4, they actually discuss the area of land that is already protected open space in the town. This is 2009. Page 4, the third paragraph, beginning with the words parks.
Yes.
So the Planning Commission calculated that parks and protected open spaces occupy over 5,600 acres of the land in Bennington,
Yes.
significantly exceeding the NRPA benchmark.
Yes, I see that.
Okay. And then they go on to describe, why they were able to achieve such large amount of open space. Were you aware that the town had that much open space, protected open space?
I was aware that the town had, a significant acreage. I didn't have that 5,600 acres embedded in my memory,
Okay.
needless to say.
Exhibit, this is not a cross exhibit, so it would be the documents that I've provided you that I would be asking about that are existing exhibits. There's an exhibit CS BW 11. Exhibit CS BW, I'm sorry, I said 11, I meant to say 17. Exhibit CS BW 17, email from Don Campbell to Libby Harris.
I think it's the other file, right?
Okay.
The one without the stickers. Not a yellow sticker.
Okay.
What's the number in CSBW what?
It's 17, and it says in prominent letter and words, email from Don Campbell to Libby Harris. There's a cover page.
Got it.
Before I ask you about that, and let me, I want to move in into the record, before I forget, the cross exhibits regarding open space, which were exhibits cross 5 and 6.
Is there any objection?
No,
I'm sorry, we're talking about the CS-cross-DPS 5 and -6?
Yes.
Were those the request to admit?
Yes.
Okay, no objection, thanks.
What had been previously marked as exhibit CS-cross-DPS-5 and 6 are entering the evidence.
Okay. Sorry, I want to keep up with that record keeping, otherwise I'll forget at the end. So in your, we did ask you a question about this in discovery. You've read this email before, correct?
Yes.
Objection about using this email, there's no foundation for it, and I don't even know who these people are. And it's apparently from Brad Wilson, but he testified earlier, and
The witness is familiar with the document, and I'm questioning the witness on the document. He has a discovery response 11 that states he's familiar with the document, and this exhibit has been in the record since last November.
oh, the email has been in.
Yes, it's a.
Oh, I'm
it's-
sorry, you gave it in this pile, so I thought it wasn't part of the record. So this email is already admitted as a.
Yes, it's
I beg your pardon.
exhibit CSBW-17.
Sorry, got confused.
Okay.
Anything, just to be clear, anything that's marked, that's described as CSBW is Chelsea Solar, Brad Wilson, and that list of stipulated testimony with the links, those are things that we stipulated. Okay.
Thanks.
Okay. Let me. Were you aware that Don Campbell worked with the land trust?
Actually, you know what? I have not seen this email. Forgive me. I misspoke. No, I am not familiar with this email.
Okay.
And I don't recall you asking me about it in my deposition either, for some reason, but
I didn't ask you in your deposition. I did ask in discovery.
I'm sorry. I
It's
think
okay. Just pull it out.
maybe it was provided, but I.
And I might have asked you about it in your deposition.
Recall, but
I'm going to give you your response. I'll read the question and then you can look at it.
Just a second, so what you're looking at is what?
His discovery response where he admitted he had read this email.
Okay, and the date?
The date is July 31, 2018.
And there's a number on it too, right?
It's Chelsea DPS 1-11.
And you're offering it to refresh his recollection?
Yes. I didn't think I would be needing to introduce this, and I probably won't. I'm just going to ask him if he remembers this.
yeah,
You know, I'll
I got to
just-
tell you, I had 151 questions in discovery, and it may be that that was a misunderstanding on my part. I don't recall the question. If that were the case, then obviously it may be that someone in my office reviewed it and mentioned that to me, so they were aware of it. But I don't remember this email specifically. I might have been thinking of another email, perhaps.
Just for the completeness of the record, since I don't know if you have a copy of your full set of discovery responses. Does he have a copy of this?
I do not.
Okay, and I assume others don't, so I'm going to read in a question.
Sure.
Okay, so this is from first set of discovery dated July 31, 2018, question, or I'm sorry, it's the response is dated July 31, 2018, question 1-11. Admit in an email to intervener Libby Harris dated June 16, 2017, the Vice Chair of the Bennington Select Board, Don Campbell, made the following statement regarding the project site, and then it says see exhibit CSBW 17, which is the exhibit. And the statement that is in quotes in this question or request to admit is the following. In this case, the lot is small, there is no river or lake to protect, the forest is in terrible condition, Friend's basal area is so low it barely qualifies as forest and it is rife with invasives and friends. It does not connect to other conserved lands. It is not part of an animal corridor. It does not provide significant public access. It is not high-quality farmland, nor is it suitable for low-income housing, and it is not tribal or cultural heritage land. End quote. And so I've read the question in the record. Your response to that request to admit was admitted.
Yeah, so, but that's not what this email says.
I'm sorry, but it does, and I can direct you.
She didn't read the whole email, but the email, which is in CSBW-17, in the middle of the.
Oh, I see that, yes, all right.
Right.
Okay, so I don't think here's where I got that. I think I had seen Mr. Campbell's comments, yes, and I can't remember whether it was in a select board minutes or that and maybe that was, I was confused. I know that I was aware that Mr. Campbell had an opinion with regard, an individual opinion with regard to this property. So to that extent, I was not falsely admitting something I hadn't seen. But so I was aware, hadn't seen this whole email as you had provided to me, but I do remember Mr. Campbell's opinion about the property. And I don't know whether that was in a select board minutes that I may have looked at or an excerpt from an email. So I may have confused the two. I apologize about that.
No, it may have shown up in a brief or two that was filed by one, but I guess my question now is, you need to say us for a minute to review the agreement.
I don't have any further questions on it.
Okay.
He's pretty much,
Okay.
I wanted to get him, what I wanted to do was offer him an opportunity to explain why he changed what looked to me like he changed his admission. But I don't have any questions on the email.
We were familiar with that quote as it was filed in another Chelsea filing. Not it in the sense that it was in this full email format. That's just my recollection of it.
Okay, and I'm, okay. It really was to address, the line of questioning was more around whether the property itself qualifies based on the town's perspective as open space type property.
Mr. Hamilton, do you have an objection?
I'm not sure because I don't have a copy of the actual request to admit, and I was not clear on what that says versus, and now there's some quote, and is it this email? So I'm, I guess, just going to wait till across to try to understand exactly what the position of the witness is with regard to admitting or not, whatever the question is from the discovery. Because it seems like that's something different than the email.
And then I'm not moving from question and answer 11 into discovery. We've already read it into the record.
Okay.
But my question is this: do you think that statement by Don Campbell qualifies as a recommendation that would be considered within the context of 248B1?
Objection. What statement are we talking about?
I'm
The whole
talking
email or this thing that's in the discovery, the quoted?
the quoted language from the discovery. It's a portion of the email, and it characterizes the parcel. I think the witness understands the question.
And if you would just repeat the last part of that question again.
Well, and could I just, if we're going to read an excerpt from this into the record, can we go ahead and also do the next set which talks about what its main attribute is?
I think you could do that on redirect, but
Okay, but I just, if you're going to ask him to his opinion about what was read into the record,
we could frame it as the email, and my question is, do these statements by Mr. Campbell reflect a recommendation of the town?
No,
Okay,
it's his personal opinion.
okay.
just about noon. How much longer do you think you can do?
So you have to do that.
Well, how much longer do you think you can, how much more time do you think you require? You have until 12:40. So
Okay.
you have another 40 minutes based on the request for time. Ms. Dingledine has an hour, but she promised would be shorter if we let her go later, so she has less than an hour.
I will stop at 9, or at 12:40.
Okay.
So I don't know that I need that much time, and I will, there are a number of other reports that the witness has provided in Public Utility Commission proceedings. I was gonna walk through at least 3 of those, and what I may
Okay,
do is
okay.
get them admitted into the record and only address one.
If you're gonna stick to the schedule, that's fine, then we can
Yeah.
take a break at
I'm-
12:30.
Yeah, I'm at the last portion of my questioning.
I did, when I was asked earlier today if I wanted to go first.
Which is what you were scheduled to do.
Oh, I didn't know I was scheduled to do that first. Okay. Didn't realize that. I thought it was, so my point was my cross would be much longer if I was not second, because I didn't want to be duplicative of what these
Right,
folks were
I
going
understand.
to do.
My
did I-
inference, my conclusion is that you would need less than an hour because it would be shorter than what you were planning for.
I'll try to be as short as I can. I didn't know I was compromising the hour that we
Okay.
estimated.
You'll get your hour, but not an hour and a half or 2.
Understood.
I will try to go through this quickly. Cross exhibit 11, it's got a sticker on it, and it's assessment and review of aesthetics and orderly development of the proposed bathtub solar project. 11, it's a, do you recognize this document?
Yes, I do.
This was prepared by Landworks?
Yes.
Was this prepared by you?
No.
Okay, but under your supervision?
Yes.
Okay. And it's dated August 2018, correct?
Yes.
And the Babcock Solar Project is another 2.2 megawatt project, is that correct?
Yes.
It's being proposed in the town of Brandon.
Correct.
Were you aware when you wrote your report that that there were public comments that had been provided, one by a neighbor and the other by the Rutland Regional Planning Commission?
If I could just ask a question.
Sure.
Foundationally. Did you prepare this report?
This report was actually prepared by an associate of mine. Yes, I guess under my supervision, I would say under my auspices, rather than supervision.
Did
So
you review the report before it was submitted?
I did.
Okay.
So I am familiar with the report.
Let me just follow up with that. And in fact, this report was an exhibit that accompanied your pre-filed testimony that was filed in that case, correct?
Correct.
Okay, so you sponsored this
Yes, I did.
report.
Okay.
Yes, I
Thank you.
absolutely.
Okay. Were you aware when you prepared this report that a landowner and the Rutland Regional Planning Commission had filed public comments with the Public Utility Commission raising concerns about the project?
Yes.
Okay, but you didn't mention that.
Again, I did not write the report. So it was not, I endorsed the report. The report was submitted by Landworks, read by a different individual in my office. And so I didn't write it, I'm just being honest.
That's fine. But you did provide it as an exhibit with your testimony in that case, which reached conclusions and provided opinions to the commission in that case, correct?
Right, and maybe to get back to your question about was I aware and why didn't I mention that, is because I didn't write it and the other individual in my office clearly made the decision not to. that's how I would have to leave it.
On page 2 of this report, I'm sorry, Ms. Raphael, it's actually I'm referring to page 1 at the bottom of the section 1.2 general approach.
Yes.
You make a note that locations that involve residential areas in close proximity to the proposed solar project are considered, although review of aesthetics under section 248 using the Queechee analysis specifically does not guarantee that views from individual homes and properties will never change. Correct?
Correct.
And on page 4, at the bottom, the very last paragraph, where it's in the section, the aesthetics assessment, section 1.4, page 4 bottom, last paragraph, you have the statement that our analysis for energy projects subject to section 248 approval does not end, however, with the results of the Queechee test. Instead, our assessment is significantly informed by the overall societal benefits of the project. And beginning with significantly and ending with project, you have that in quotation marks, correct?
Correct.
And you've cited the Northern Loop project in docket 6792 as the basis for that quote, correct?
Correct.
In this case, you did not in your methodology section of the report mention the societal benefits standard that's now incorporated in the modified version of the Queechee test that the board applies, correct?
Correct.
Okay. The project in that case, on page 5, you describe its surroundings.
Can we just clarify, when you're saying you mean the report, not you, because they testified you didn't provide it, correct?
The report is sponsored by Landworks, Mr.
Well, if you as Landworks, that's just what
Let me phrase it this way, and when I say you from now on, I will mean Landworks, but with the understanding that Mr. Raphael reviewed this and attached this as his exhibit and supporting his testimony in that case. Correct?
Well, again, it is a Landworks exhibit, and I think again we have to make that distinction because I did not. I certainly sponsored the report and the testimony. I did not write the report.
You're the principal of Landworks?
Yes, I am.
Did you? Okay, I will refer to Landworks. I think we have the understanding of context.
I mean, if I may, Ms. Hayden, for your information, we had a period of time where we were involved in quite a few solar projects, transmission projects, wind projects in Maine, and in our office, one individual took on all of the solar work. And in fact, there are quite a few projects that she wrote, she analyzed. I had no involvement with it whatsoever. I mean, I'm sure you can understand that a large firm could have a name on the cover, but that an individual or one element of that firm wouldn't have done the work. So I just wanted to make that distinction. And the other piece to that.
I'm a little bit confused. So, did you adopt this report?
I did sponsor the test.
And you sponsored it? Okay, we'll treat it as such. This is the exhibit that you submitted. That is the report of Landworks for that case. And you sponsored it in that case.
I did.
Very well.
I had a question, but it's evaporated. Let's turn to page 5. The Babcock Solar Project is located at the edge of Brandon Village in the rural residential land use district. That's what that's a zoning district, much like the rural conservation district is a zoning district, correct?
Well, there's one very important distinction,
Okay.
and that's in the nature of the district designation. It's called rural conservation in Bennington for a specific reason and with standards and representations that support that. In many communities like Brandon, like my own hometown, rural residential districts are just that. They are understood to be a lower density, rural quality, and not necessarily intended or described as an area for conservation per se, or conservation of certain values that are articulated. They can be, but they may not be. So I think there's an important distinction when a town designates a district as conservation versus rural residential.
Well, let me just, on that point,
Sure.
the Bennington Rural Conservation District, you've already testified, it makes up over half of the area of the town of Bennington, correct? And it doesn't preclude solar development, correct?
Correct.
Okay. So there are no policies or goals regarding conservation of this project, meaning the Chelsea Solar Project site in the Rural Conservation District of the town of Bennington, right?
No, I think I disagree with that. I think there is language and standards or yes, directives to consider certain conservation elements and conservation-related practices to sustain the conservation nature and intent of that district.
Okay.
Which, for example, Brandon did not have under the provisions of the rural residential district in that case.
Are you aware that Bennington has both a rural residential and a rural conservation district? It's in the town plan, so they have both. So they allow for that distinction.
Let me refer you to page 6 and your discussion, or you Landworks discussion of open space.
Yes.
It's a short description, or discussion, I should say. It doesn't include the definition that you had in your Chelsea report about open space views, right?
Correct.
Why is there a difference in the Landworks report on open space with respect to what this report says is the project does not affect any conserved lands or open space identified for public use for future conservation? That's the standard that you applied in the Babcock solar space in terms of defining what open space is, correct?
Well, not entirely. I mean, I think what's not said is that it certainly, I think, was a consideration that the open space in this sense did not have applied to it some of the factors and characteristics, for example, that the open space that Chelsea will impact has. And I think that's an important distinction. Two different projects.
I understand that. I'm just talking about the standards that you're applying and this concept that open space encompasses views, not just publicly accessed open space areas. That's quite a distinction, don't you agree?
Not necessarily. I think this project warranted a certain review and assessment based on existing conditions and the character of the area and the context within which the project is being proposed. Chelsea warranted a whole different set of considerations given the district and the location and the open space that it would impact.
I just want to ask a question to be sure. But Chelsea is not located in an identified open space area that's amongst those 5,600 acres.
Correct.
Earlier I'd asked you if you were aware of the fact that at least one resident had filed a public comment and had concerns about the project, correct?
Yes.
Have you read what was filed on EPUC?
I think I did. I
Okay.
I did see that.
I'm gonna, exhibit cross DPS 17 is a printout from the Public Utility Commission's website. If you go to public comments tab and you wanna print it, this is how it prints. I printed it myself. The first couple of pages, I think, really give you more information about what the case is. Let me let you find it first. And there's a comment on the last page of that exhibit, March 21, 2018, from Carol Byrne, B-Y-R-N-E. Do you see that?
Yes.
Is that the comment that you had in mind when you said you were aware that there were public comments?
I think that was at least one of them that I've been aware of. I've also, it was brought to my attention some public comments in newspaper articles relevant to this as well.
The last sentence of that, she states that she's a homeowner in proximity of the proposed solar project, or homeowners in proximity of this proposed solar project are very concerned. And her last sentence states that without question, it will create an intolerable, not adverse, an intolerable view of black solar panels filling the fields next to Park Street Extension. So, I think we were discussing, the reason I raised this exhibit with you is because you were trying to characterize or distinguish the open space standard that you applied in that case, in the Babcock Solar case, and here. And you made a distinction, is it correct?
Yes.
And you made a distinction based on, correct me if I'm wrong and disagree with me, but I thought what you said, it kind of depends on the reaction or the importance of that open space area in terms of how it's been perceived.
No.
Yeah, okay.
No, that's not what
Okay.
that's not what I was. I think two quick things. One is that, again, as I said earlier, you know, the Chelsea site clearly has some other town-developed representations and narratives that relate to that site with some specifics and some guidance as to how that site should be considered. Brandon has no such representations. It's not part of the gateway. It's not called a conservation district. And I would also add that this comment was made before it looks like if I have my dates right, I'm fairly certain this comment was made before there was an opportunity subsequent to that to present to the town and the community an appropriate screening and mitigation plan. And so I think it was provided without a full set of information that the applicant has taken suitable steps to mitigate the view of the project from adjoining residents.
Well, let's talk about mitigation in Babcock Solar. You discuss, Landworks discusses that at page 13 under section 2.2C. This is the Queechee has the applicant taken generally available mitigating steps which a reasonable person would take to improve the harmony of the proposed project with its surroundings. Do you see that?
Yes.
Okay, and the first sentence in that section, you state that the selection of an appropriate site is the first factor in consideration of mitigation measures.
Correct.
You didn't make that statement in your report in this case, correct?
Right.
In fact, you criticized Mr. Kane's report for identifying site selection as a mitigating step.
Yeah, this is a difference of opinion. I don't think this is saying it is a mitigation step. I guess it says it's an important step because of the characteristics of the site. I think there's a difference of opinion as to how to articulate that. And I think some people have come out and said site selection could be considered a mitigating factor, but it's not typically what we normally think of under mitigation, because clearly the mitigation is more designed to mitigate the effects of the project as proposed. So I think in general, clearly, site selection is very, very important, but it could be considered a mitigating factor under that step of the PUC review. That is subject to a difference of opinion, I think, among experts.
Well, I'm confused then, because this sentence says, the selection of an appropriate site is the first factor in the consideration of mitigation measures.
Yes, because if you select a good site, then it's likely that the mitigation measures required could be lessened or reduced dramatically.
Okay.
And that's because the site, by its nature, mitigates concerns.
Correct.
And I think we talked about this during your deposition. Would you agree with me that retaining screening around the periphery of a site, vegetative screening, clearing all of that screening, that's also can be a measure that's considered a mitigation measure?
Yes.
And in this case, the applicant had modified its plans to reduce the amount of tree clearing so as to retain more screening. You're aware of that, right?
Yes.
That was an appropriate mitigation measure?
Yes.
Okay. We were just talking about the Rural Conservation District. Do you agree with me that that is a zoning district?
Yes, but it's also a land use planning and land use plan element in the town plan, and identified as such.
All right, I think what I'll do is, there's Exhibit Cross 10. Just want to spend a little bit of time on another solar project that you reviewed. I believe we discussed this at your deposition. Did you prepare this report?
Yes, I did.
This was for a 2.2 megawatt project, solar project in South Burlington, Vermont, correct?
Yes.
And it's dated 2010. Did you provide this report with testimony that was submitted to the Public Utility Commission requesting a CPG?
Yes, with the clarification that at that time it was the Public Service Board.
Correct.
Sorry.
That's fine. Let's look at your discussion of the district, or the area in the town where South Burlington, it may be a city, of the municipality where this project is located. You say at the top of page 6 of the report that a portion of the project site also falls within an area designated by the city as a scenic overlay.
Yes.
Was that a scenic overlay district? Is it a zoning district?
I mean, typically an overlay is part of a zoning provision, and so, I don't know if you could call it a district, but an overlay actually could encompass more than one underlying district. I mean, I may be, using words here, just being particular, but.
Okay, that's fine. You've answered the question. Page 2, when you describe the project, and although it's a similar project in the sense that it's 2 megawatts, this project was, the design was for all sun tracker solar panels, and the project would occupy 22.5 acres, correct? So all trackers are much larger types of solar panels, correct?
Yes,
They have a higher profile,
yes, they do.
and you get into that in your description, so we don't need to belabor that. Page 7, 6 and 7, you talk about the project's compatibility at the bottom of page 6 with its surroundings, and you have a discussion at the bottom of 6 about the nature of these installations is such that they are developed as an array of moving panels that follow the course azimuth, A-Z-I-M-U-T-H,
Yes.
of the sun to maximize the solar potential, or the solar gain. And I guess there you determined that because these trackers basically follow the sun, that they're compatible with the surroundings?
I don't see where you get that.
Well, only because the header is the project's design compatible with its surroundings, and you talk about this feature of this type of solar design following the sun, and capturing energy capture function of solar power generation. You say that at the top of page 7. Did that inform your determination about the project's compatibility with its surroundings?
I think it was really just a descriptor, and that the second paragraph, I think, is the more relevant one, in which, we describe what the fit is, and the low profile, I noticed, is not referring to the structures themselves, but the fact that this project was in a low area, below neighborhoods, and below any views that were part of that scenic overlay, which was designed to protect views from, I think it's the road, it's the nearby road, and a context map here, but the views are from the road, the main road above the area and the neighborhood, the Heinsberg Road, maybe I think it is. And because the project itself was quite a bit away below the project road elevation, it would have no interruption or even presence in the long distance views to the western foothills of the Green Mountains that the overlay district or designation was designed to protect.
In that case, in your report for that case, like in Babcock, you don't mention the societal benefits consideration under Clichy, correct?
Correct.
I'm sorry, you mention it on page 1 of your report. You didn't in the Chelsea report. You have a panel on page 1 that specifically highlights the societal benefits of the project.
Correct.
Okay. Or of a project, and that's a consideration under Clichy, correct?
Yes.
All right. I also had marked as Exhibit 15 your testimony in that proceeding. If you want to turn to that, I just want you to identify it for the record and confirm this is your testimony.
What number is that?
It's cross 15.
Yes, that is my testimony.
All right. So your testimony accompanied the report that we just walked through.
Yes.
Okay. And it's true and accurate to the best of your knowledge?
Yes.
It was prepared for that project?
Yes.
Has that project been built?
Yes.
Okay. I would move the admission of exhibits. The Babcock Solar. Yep. Exhibit Cross 11, which is the Babcock Solar Report. Exhibit.
Is there any objection?
Objection on relevancy. He's been cross-examined and there are questions in the record. Why do we need another document from a wholly different case?
If the report provides the full context, it should be in the record rather than.
Completeness overruled.
Did I just move, I moved Exhibit 11.
Yes.
Okay, I'm also moving Exhibit 10, which is the Landworks Aesthetic Report for South Burlington Solar Farm, together with Exhibit 15, which is pre-filed testimony of David Raphael, Ray South Burlington Solar Farm.
gonna object. These are surprise documents. No one's had, I haven't had the opportunity to review them. And what's the relevance of this? You know, it's dangerous precedent. I guess the next time I come to cross-examine Mark Kane, I'll bring every single document he's ever filed in any case. I mean, I don't understand. We're talking about this gentleman, if you want to assail his credibility.
Well, I'm not gonna, I can see a relevance in as much as these documents challenge the quality and nature of the assessment that was conducted in this case by using comparable cases that have differing language. Therefore, I'm going to rule the objection.
And in order to you also prepared reports for 2 wind projects, the Kingdom Wind and the Georgia Mountain Wind case, correct? You were the consultant for the petitioners for both the Kingdom Community Wind Project and Georgia Mountain Community Wind, correct? I think we worked together on Georgia Mountain Community Wind.
Yes, we did.
Okay, and I have marked as exhibits Cross DPS 8 and Cross DPS 9. Cross DPS 8 is the Kingdom Community Wind Project. Aesthetic assessment, it says aesthetic assessment includes orderly development and public investment. Do you have that in front of you?
Yes.
That was prepared by Landworks in 2010. Is that correct? It was marked as exhibit petitioner in the bottom left-hand corner, DR2. So I take it that means David Raphael too?
Yes.
Okay, did you write this report?
I wrote large sections of it, but not the entire report again. I work with a team in my office.
And it was offered into evidence in support of obtaining a CPG for that particular project, correct?
Correct.
And has that project obtained a CPG, to your knowledge?
Yes.
And it's been built, in fact, correct?
Correct.
I'm going to move the admission of Exhibit CS Cross DPS 8, and it's for the very same reason. The relevance relates to the standards that were applied and relied on, which are different than what appears in Mr. Raphael's report here.
Is there an objection?
Objection. I don't know whether who's testifying or if that's an offer of proof, but,
Yeah, and I also find it duplicative. I'm not sure why we need to have more than a couple to challenge the credibility and quality of the assessment in this case. I'm sure there are probably I'm sure he writes no 2 reviews in the same way. And you haven't really highlighted in this one why this one challenges the assessment in this case, and the other 2 you did. I think you're just adding them to the others. I can't see a reason why I would look at it when I'm making my decision. Therefore, I'm going to sustain the objection and not admit these documents.
But I'm done.
Okay. Great. It's due, and we have cross-examination. I think I'd like to take a 15-minute break, and then Ms. Diegoldine will have until 2 o'clock. So we'll come back at 1:45, and then you'll have until 2, and then we have to secure, because I need to eat lunch and I need to clear the room before the next event, which I'm also in.
I'm happy to go even shorter, so DPS has an opportunity.
We're gonna have a little bit of.
Oh, I'm sorry. Do you want to do redirect now?
Probably rather, let's delay.
You want to do redirect at the end? Okay. Let's take a 10-minute break and come back at 20 minutes before the hour.
Do you want to wait until after your... Yeah.
All right, it's 12:45. This is the hearing in case number 17-5024-PDP is back in session. Parties are present, and we want to recess are present. Mr. Raphael is still on the stand and still under oath. I just wanted to note again for the parties that during the break, I went up and was informed that I absolutely have to have an empty room here at 2 o'clock because there are certain security measures that need to be applied for the next session, which I have to be back in here at 2:15 to set up. So we're going to want to make sure we have enough. You can't linger at the very end like we might otherwise. With that, Mr. Goldine, Mr. Raphael is your witness for cross-examination.
Mr. Raphael, I'm going to try to move very quickly, but I'm going to be jumping around to different topics. So please let me know if you're not sure what I'm talking about. Were you familiar with the Public Utility Commission's decision on petition of Chelsea Solar LLC from the first docket, issued in order February 16th of 2016, that determined that there would be an undue adverse impact on orderly development and aesthetics?
Yes.
And are you aware from your review of that particular decision that the Public Utility Commission believes that the town plan, in fact, is the equivalent of a clear written community standard?
Yes.
Okay. I've heard some information yesterday, and I think it was referred to very briefly today. In terms of town planning documents, is it your experience that they set goals and they're basically planning documents that express aspirations of a town?
Certainly.
And then zoning ordinances or other kinds of ordinances are more in the regulatory arena in terms of implementing those overall goals, and they should be consistent with those overall town plan expressions of where the town wishes to go.
Yes.
Okay. But in this process and in Act 250, in the criteria that were imported from Act 250 to this process, compliance or violation of the town plan, for example, is something that needs to be looked at in regards to whether or not that clear written community standard, which a town plan can be utilized in that regard, whether that, so you recognize that town plans, in fact, generally in Act 250 and certainly in this arena, are regularly used, and many times are found not to have clear written community standards because they're too aspirational and don't have mandatory language, for example. Fair to say?
Yes.
Okay. So in terms of the decision that previously issued in this case, the PUC said there was approximately 10 acres for this site, and we were corrected yesterday that the applicant believes that that project was actually 14 and change in terms of the acreage. But given that the PUC has already determined that the 10-acre site would have violated the two criteria, orderly development and aesthetics, vis-a-vis the evidence it had before them and the applicability of the town plan specifications for the Rural Conservation District. Do you believe that that prior precedent, because I think that your report does refer to prior precedent, is applicable in this proceeding in terms of, number one, whether or not the town plan is a clear written community standard with regard to orderly development and aesthetics, such that its applicability is consistent now and should be applied in this proceeding?
Well, I think in terms of the orderly development piece, that the town provides some guidance, if not certainty, about how they view this area and the district in a general sense, and one can take from that and apply specific considerations to this site that certainly could be construed as a standard in that regard.
The PUC also determined in docket number 8302 that the project violated 3 of the 4 specific requirements in the town plan for development in the Archon district. And so those 4 criteria, 3 of which had been violated before, are also applicable to this proceeding, correct?
I think those considerations are applicable.
And they are clear written community standards, which was the determination of PUC in the prior Chelsea application.
Well, I think again, this is a tough one, and I did struggle a bit with, where we reach that threshold, and this notion of community standards is still subject somewhat to interpretation. Obviously, the more specific you can be, the better in terms of applying a standard. As this, it's been a long project. There's been a lot of changes and other factors that have to be considered. Not the least of which is the potential presence and approval of the Apple Hill project, and therefore taken together, I think one could construe that if you view them as standards, they are still certainly applicable.
In the first Chelsea case, the PUC said that they appreciated the efforts of Chelsea and the Public Service Department to propose unprecedented and costly vegetative screening to mitigate the visual impacts of the project. But the PUC went on to say, however, our conclusion that the project would violate a clear written community standard intended to preserve the aesthetics or scenic beauty of the project site and its surrounding area concludes our analysis of the aesthetic impacts of the project using the Clichy test. So would you agree with me that the PUC has thereby acknowledged that you come to us with a project, and that is what we are here to decide whether, as proposed, the project does or does not pass the various criteria that are at issue?
Yes, I would agree with that.
Okay. And so at this point, we know what the proposal is, we know what the screening components are. Could you just briefly comment on the screening that is proposed? Because I think you had information in your report that expressed concerns about the screening that does exist, that's proposed.
Yes, several things. One is, I think we are finding, and I have specific experience and specific examples, that yes, we rely on screening as a tool, and it can be effective, but the establishment of effective screening is much more of a challenge for any number of reasons, and I think that has been evidenced in some other, as I mentioned, instances and cases where a project was approved with mitigation screening required, and that mitigation screening either has taken too long to establish, has not established itself effectively, or has failed because of circumstances which aren't always considered. And I've learned over time that it's wonderful to draw circles on paper and say, these trees are going to block the view and so forth, but it doesn't always take into account how those mitigation plantings are going to be installed and managed and maintained over time, number one. Number two, it doesn't necessarily consider or take into account the site conditions themselves. For example, the mitigation plantings in this project are proposed in some instances in areas where there's going to be a lot of shading, and so their establishment and growth could be affected by that, and I've seen that happen. And then relying on the mitigation measures of the surrounding buffer, I think is a double-edged sword, and I'm also painfully aware of that in the sense that, yes, there's a buffer, and yes, to the applicant's credit, and I do refer that to that in the report, steps have been, I think good faith steps have been made to provide mitigation, but there is no recognition that the buffer being relied on could in fact, be greatly impacted by conditions beyond the control of the applicant. And I'll give you two examples. One is to Mr. Campbell's quote that I was asked to comment on earlier, and he talked about this is not a high-value forest. It's degraded, it's got invasives. I mean, show me a forest in the valley of Vermont or the Champlain Valley that isn't fighting invasives, depending on quality. But that's maybe beside the point. One thing I noticed was that the stem density, and he talks about this, references it. The stem density of the surrounding buffer is very open. I mean, in other words, there's not lots of big trees and lots of evergreens, stems, individual plants in the buffer. And there's also, I observed on our site visit, quite a few ash trees in that buffer, which, as many of you may know, are also under threat in Vermont now that we've established that the emerald ash borer is here. In fact, the town of Rutland, the city of Rutland, is taking the drastic step of removing all their ash trees in that regard. And so that's a factor that has to be considered in terms of the integrity, efficacy, and longevity of the buffer that we're relying on, so beyond the mitigation plantings, number one. Number two, because of the stem density being very, very small trees, and fewer larger trees, screening in winter is going to be less effective. And finally, number three, the effects of climate and wind. I have seen buffers left that don't last, because once you remove a forest cover, no matter what the integrity or health of that forest is, you're creating gaps that other trees rely on. Individual trees in a forest, particularly taller ones, rely on each other for support. The minute you do a large clear cut, like is being proposed in this project, is the minute you are exposing some of those newly opened up trees to things like sun scald, wind throw, more perhaps susceptibility to pests. So those are the concerns I have with regard to mitigation.
You talked about the fencing, the black against the snow cover. You have indicated that would stand out more drastically than against a wooded or a non-wooded background, but a non-snow cover, correct? So in terms of the requirement in the town plan for earth tones, do you believe that black is an earth tone?
No, but I will say in defense of that, honestly, that we found that black material, black fencing, actually is really better absorbed as sort of background trees. It's not quite as visible, with the exception certainly being in the snow cover condition. So I think when you're talking about large surfaces, no question that earth tone is important and amenable color schemes. But I think in terms of the fencing, the black is the right choice.
And the black is the color of these panels as well.
True.
So is it not true that this would appear as a big black mass?
I
From
think
Ferris
there is that
vantage.
potential, yes.
Okay. I'm going to ask you, you've reviewed pre-filed testimony in this case.
Yes.
Did
Not all.
Did you review the pre-filed direct testimony of Daniel Monks, who's the planning director of the town of Bennington?
Yes.
Okay. So you read the actual document?
Yes.
May I approach the witness? Sharon?
I'm going to object if he's going to be cross-examined on the Monk's testimony, which has been withdrawn. It hasn't been offered into evidence in this case.
By the town, it doesn't mean she can.
The Monk's
As long as she can provide a foundation.
I'd like to hear.
Your Honor,
Please.
just gave you that I marked for identification as cross one.
If we could just make to ensure it's not confused with any of the other cross exhibits, that it'd be INT-cross one for
Oh,
interveners.
for the interveners, okay. INT cross one, which is titled Pre-Filed Direct Testimony of Daniel Monks as Planning Director for the Town of Bennington. And that's docket number 17-5024-PET. This is a document that you are familiar with, that we were just discussing.
Yes,
And you did have an opportunity to review that in detail prior to today.
yes.
I would move the admission of this document and then would like to cross the witness on it, given that I've laid the foundation for the document.
So where did this document come from?
This is the, Mr. Raphael, is this the document that you reviewed during the pendency of this case in terms of your review and then ultimately in your job in conveying your expert opinions in this case?
Yes, but I would point out that this was reviewed after I developed my report.
Okay. But you believe this to be the same document that was actually filed in this case by the town previously?
Yes, I believe so.
I would move the admission of the document.
Objection.
Basis?
There's no foundation. This witness can't authenticate the statements that are made in his pre-filed testimony, and if I would imagine that he's going to be asked his opinions with respect to the statements that are made in his pre-filed testimony. The other basis for that is that the town specifically withdrew this testimony from the record because it doesn't reflect the current position of the town. The town is settled with the petitioner, and it would be misleading to both have this in the record and to cross-examine this witness on it. I think under Rule 403 of the Rules of Evidence, it's prejudicial and it would be misleading.
I have a question too as to relevance, given the fact that Mr. Raphael said that this document did not inform his assessment. What is the relevance with relation to this individual?
Because I want to determine whether or not he takes the information contained therein, because part of his testimony in his expert reports pertain to the position of the town, the position of the interveners, folks.
Well, he just said he didn't read it until after he wrote his report.
I understand that, but I think I should be entitled to ask him, now that it's authenticated, whether he agrees or disagrees with the issues contained therein about the gateway of Bennington, the location of it, which is described by this particular witness, to see if he agrees with and whether this position expressed in this document is consistent or supports or not the opinions that the witness has already placed into evidence.
If this is no longer being offered by the town as its interpretation of its own plan, why is it relevant?
Well, just like we have some email from a guy who this gentleman actually indicated is a person, even though he might hold a position. This email is being used by the applicant.
So this individual is the planning developer, or the planning director for the town of Bennington, and on June 22, 2018, he rendered a statement that was otherwise previously filed in this docket that has been withdrawn by the town. I'm going to allow its entrance into evidence with those, with that context.
I would note that the stipulation entered into between the town and the petitioner calls for that not be in the record. And so admitting this now after the fact without the town's consent is inconsistent with the stipulation.
Public record.
There's no consent needed because they're not a party any longer. And just
Never.
because they said something before, and as we demonstrated yesterday, Mr. Wilson has all sorts of quotes from the town's attorney who said something at a select board meeting. This is to meet that evidence.
I'm sorry, can you show me where in the stipulation this specific aspect is addressed?
it's on the very first numbered paragraph. In consideration of mutual promises and representations and intending to be legally bound, the town having an opportunity to fully review and assess the Appleton project and the Chelsea project, agree not to oppose either of such projects. The word not to oppose with respect to Appleton and Chelsea shall mean that the town shall withdraw the testimony of Dan Monks in the Chelsea proceeding.
Okay, well, they've done that. I don't see that precludes another party from entering into evidence and having all the indicia of the piece of evidence that would be entered. So I'm going to overrule your objection and allow the admission into evidence of this document. So INT cross 1 is admitted. You may proceed.
Thank you, Your Honor.
Recognizing, however, that he did not use this document in preparing his testimony.
Understood. Mr. Raphael, earlier today you testified that the more you have considered this after the filing of your pre-file testimony, taking into account some opinions that have been expressed by others, you reconsidered particularly that gateway area issue. Was Mr. Monk's testimony part of the information that you considered in terms of now evolving to the point of recognizing that in this case the gateway areas issue is of higher concern than when you actually wrote your report?
It reinforced the decision or the consideration that I came to with regard to the gateway. I wouldn't say it influenced me in that regard. Certainly I was aware of the gateway. The more I understood and looked at the physical parameters of that gateway, and as certainly informed as always by any visit to the site, and our last site visit with the PUC added to that, so I guess it was a
I want to
reinforcement.
ask a question. So this has been withdrawn by the town.
Correct.
The town does not call this their position.
Understood.
Does that influence your opinion? Proceed.
Thank you.
So it's not a town recommendation.
I understand that.
Okay, it's a private individual who.
Well, yes, but who has some standing as a planner and as a planning director.
Understood.
I'm going to object. We're treating this as if it were testimony being offered in the case. I have not had an opportunity to cross-examine this witness. And so, therefore, or the testimony that's provided, I took a long deposition of Mr. Monk's, and there were a lot of significant areas that we identified, which I would have covered on cross-examination. So offering this testimony into evidence and allowing the witness to treat it as if it were testimony by the town or an individual within the town, but somehow purporting to represent the town's position, I think is completely inappropriate.
Understood. Overruled. You may proceed.
So if that's in evidence, we're going to move on to something else because we're really time limited, and I want DPS to have their full opportunity with you. The Rutland Renewable Energy case, that is part of the documents that the petitioner brought today, the one that you said you were not that familiar, you hadn't read or didn't know about ahead of time.
Right.
Let me just read you one sentence, and I want to ask you if you agree or disagree. On page 10, the very bottom of that document, the decision says, in determining whether there has been an undue adverse impact, considering the sensibilities of the average person, the board can and should consider all vantage points, including from private property. Do you agree with that in terms of the analysis under Queechee for what vantage points should be considered?
Yes, and I think in previous cases, including one that Ms. Hayden wanted to introduce but didn't, the applicant's witness, Mr. Kane, highlighted a private property that was going to be impacted by Kingdom Community Wind and, no, I'm sorry, excuse me, not Kingdom Community. Let me correct that, I think it was Sheffield. Mr. Kane highlighted, on behalf of the department, in fact, a private property that then became an important consideration in the review of the project. So while we are concerned with the public realm and the public view, it doesn't mean we exclude consideration of private properties, and in particular where they comprise neighborhoods.
And so your analysis in this case, in considering the surrounding neighborhood, is in compliance with that standard that the Vermont Supreme Court has articulated in a recent case, correct?
Yes.
The Supreme Court went on to say, we acknowledge that in addition to considering neighbors' interest, the board ruled that the test definition of an average person meant the average member of the viewing public who would see a particular project from the vantage point of the public. That is, while the board must consider all vantage points, it does so from an objective as opposed to a subjective and neighborly perspective. Do you understand and agree with that statement?
Yes, I do.
And your analysis has been in compliance with that Supreme Court precedent in terms of looking at the private views, but analyzing them from an objective, not from the subjective neighbor's perspective. Fair to say?
Yes.
Thank you. One thing I wanted to ask you about that letter that you sent to Peter Shumlin and Commissioner Elizabeth Miller on the Energy Siting Policy Commission thing. You talked about sometimes towns, you mentioned the word hyperbole, and that sometimes they would be unsubstantiated information might drive a town to get involved or to overreact, I guess. Is that a fair way to say that?
Yes.
Is it also your experience that there are many, many towns, especially small municipalities, that do not intervene in proceedings before this body or Act 250, for example, because they just don't have the money or people who have the level of expertise, knowledge, or understanding of how to be involved in those processes from the perspective of the municipality?
Yes, absolutely.
Sorry, I feel like I'm drowning in paper. In terms of the views that you highlighted in your report and your testimony today, you do believe that the views from Mount Anthony Country Club are important in terms of whether they would be impacted. That is an important vantage point in your opinion?
Yes.
Okay. Have you had an opportunity to see the Sir Rebuttal testimony of Mary Leon, the owner of the country club? There are a number of photographs from those vantage points and others within the town.
Yes, I did look at that.
Okay. Are the views from the country club, you've been there, you were on the site visit, do you think that they're fair and accurate representations of what it looks like when you're standing on the golf course from those vantage points where the photos were taken?
Which views, though, are you referring to? The photographic views, the photographs that presented, or?
Right, the photographs from the actual country club.
Yes, I mean, I think those certainly, from her perspective, provide a sense of the viewscape that she and the operators of the golf course feel are important.
And just because they weren't with some special camera or lens or whatever, and might have been taken with an iPhone camera, is there any reason not to look at those views, remember back to the site visit, and appreciate them and give them some weight in terms of evidence?
Yeah, the views provide information. You know, you will have to, and you do have to distinguish between photographs that are taken for simulations. Simulations provide, or attempt to provide, a more accurate view of what the eye would see with the project in place, and therefore there are certain parameters that are accepted among experts for creating those types of simulations. In terms of representative views of the area that are put into reports or used as evidence to provide information about what one might potentially see, I think they're valid.
In terms of simulations that were introduced by the applicant, do you think that they provided sufficient simulations from places that you believe are important within the town, like the Mount Anthony Country Club or other public venues like the Welcome Center area?
You know, again, there were several new simulations submitted by Mr. Busher, I believe, and I was struck by the fact that he looked in two different directions, but not straight ahead with his simulation. But that's the choice, I guess, of the individual preparing those simulations. The simulations provided, as I said earlier, by Mr. Kane, I had a lot of trouble with because I do not think they're an accurate representation, given that they use, again, not the real landscape that's present, but created the landscape to simulate the entire landscape and then simulate the changes in the landscape.
You're concerned about the cumulative effect of this plus the Apple Hill Solar Project because the total clearing would be over 19 acres?
Yes.
And that cumulative effect, would that only enhance your concerns in terms of the undue adverse impact of the combination of these two solar sites that are literally on the same piece of property and practically touch one another?
Yes.
I'm intrigued by your testimony about site selection and as a mitigating factor. It's pretty duplicative. It kind of conflates two legs of the Queechy test into one, does it not?
Yes.
Okay. So, in your opinion, you have to figure out, is there an adverse impact as proposed? Is that an undue adverse impact in terms of as proposed? And one of the undue factors, I don't know which number it is, I've always looked at it as the third, but the mitigation, that is what steps have been taken that a reasonable person would in order to mitigate the undue adverse impact, correct?
Correct.
And the three factors for the undue analysis, each one of those must be met, correct?
Yes.
So by meshing together this notion of whether it's shocking and offensive with mitigation, to say, well, it's not shocking and offensive if you put these mitigation issues, or, you do planting or what have you, that in fact nullifies, in effect, that very first analysis of whether or not it's shocking and offensive. Would you agree with me?
Yeah, I mean, if you find that a project is shocking and offensive, as it is proposed, with even the mitigation measures indicated, which the applicant would typically do in any kind of an analysis under aesthetics, that would not change potentially the shocking offensive. It's very hard to undo, if you will, not to use the word in a different way, but to, if the project by its very nature is considered to be shocking and offensive in toto, then no amount of mitigation potentially will change that unless somehow you can bury it or you can make it go away. And of course, that would be one instance where the shocking and offensive determination could result in a mitigation measure that could change that. But in some instances, it could be considered unreasonable because of cost or impossible to implement because of site factors that would prevent certain mitigation or undergrounding, that type of thing.
Thank you very much. That's all I have.
sorry if y'all, I'm gonna be very fast because I'm not, you're gonna encounter, I think, some people you referenced earlier in your testimony from another case. Very, very quickly, do you remember, and they may try to put you on the stand. Do you remember Ms. Hayden went through with you, the 2009 Bennington Regional Energy Plan?
Yes.
And, I believe she dealt with the energy section largely, I think that maybe began on page 34. Is there anything in that report that alters your opinion of your analysis and conclusion in this case?
No.
I'll ask you the same question for the 2012 Bennington Municipal Energy Plan that Ms. Hayden went through with you. Do you remember that?
Yes.
Anything in there alter your analysis or conclusion in this case? And in the areas of the energy section, you remember she was discussion specifically about the 2010 Bennington Town Plan, and upon review of that with Ms. Hayden, does anything change your analysis or conclusion in Chelsea's?
No.
Ms. Hayden admitted, I believe, a report that had been prepared by you for South Burlington Solar System, and then one that was under your direction for Babcock. And I think as Mr. Cowsley said, these documents were relevant for her to challenge the quality and nature of your testimony in this case. How many assessments have you filed in your career?
Oh my gosh. You know, I would say maybe 100 or more.
Okay. And they weren't admitted, but I think there was some discussion of two large wind projects. Should we be concerned that in these two cases that were admitted of similar size that there was a different finding than you had in the Chelsea case?
No.
Why not?
Because again, you know, as I said before, and I've, you know, as a landscape architect, you look at sites for their intrinsic and obvious characteristics. Vermont is a very diverse state. Every site is different topography, often different vegetation, different uses, different placement, different presence in the view shed. All of those things are distinct on a project-by-project basis, and therefore each project warrants a review that reflects those differences and those distinct qualities. And often the review will be more straightforward and more direct because the project does not have the nuances or the challenges or the impacts that, you know, projects such as Chelsea and Apple Hill seem to have or have. So it really is a one-by-one type of process. And in fact, you know, I have found that it might seem that you could review two 2.2 megawatt projects with the same parameters and the same conclusions, and to that effect, certainly the Queechee provides that sameness and that framework, but the first step of Queechee really asks you to look at the characteristics of the land, not just the visibility of the project. That's one piece of it, but there are a number of other elements, and I think from my experience, every single site is different. You know, in my own town again, we have 3 different solar sites that are less than a mile apart, and each of them are completely different in terms of their setting, their siting, their effect, their visibility, and even the nature of their acceptance by the community. So, you know, you can have a neighborhood where people just don't like solar and really are offended by it, or you can have, or a town, or you can have a neighborhood where people understand and certainly, you know, respond to that need of renewable energy. So, long story short, they're all different.
And should we make anything of the fact, I think this came up, that in some of your reports, maybe most, you have this purple box that has a quote from 6860. This is not contained in your Chelsea report, is that correct?
That's correct.
Was there any,
And, you know, it was not
reason
intentionally
behind that?
left out or included. I mean, it was a standard operating procedure, I think, because we, you know, I think early on, aesthetic consultants needed to understand, you know, the parameters within which projects are reviewed. And I think that was a piece of information that for a while I felt was important to include, and we did. But, you know, there was no intention to ignore that or not keep it in this process, honestly.
Thank you. So Mr. Tousley asked you earlier if you were aware that the town of Bennington had reached a settlement in this case. And he asked you if that had changed your opinion, I believe?
Yes.
And you said no, is that correct?
That is correct.
Why not?
Because I have to do my job on my own. I have to approach this as an independent and you know, objective, to the best of my ability, analysis that I am being asked to review the project with the tools and experience that I have, you know, and have been trained to apply, you know, over, dare I say, 45 years of practice. And so, you know, that's really forms ultimately the basis of my conclusion. Those types of information are, as I have said and I have written, informative, but they are not conclusive. What is conclusive in my review, you know, is looking at a site like Chelsea and finding that a project of this nature is not a good fit there.
Thank you.
It's 1:30, do either of the parties desire limited recross?
No, thank you.
Very well. Since there is time, I may ask a couple questions.
By all means.
Either of the parties desire limited recross?
No, thank you.
Very well. Since there is time, I may ask a couple questions.
By all means. We'll temper that then.
Yeah, right. Short answers.
Okay. Yes or no? Maybe yes or no. I'm lecturing on Tuesdays and Thursdays. I think that's why I tend to talk. Forgive me.
We have no idea what you are lecturing.
My students do, though. Goodness.
Many of my questions you've already addressed, and I appreciate that. You talked to the mitigation recommendations that you would find this project to be not unduly adverse if the mitigation recommendations that you make are accepted by Chelsea. Do you know if they have been accepted by Chelsea?
I do not know. I know that some mitigation measures may have been adopted in the settlement vis-a-vis the town and the applicant, but I do not know which those are.
Yesterday, I mentioned offhandedly but purposefully Commission Rule 5.800, which addresses many of the concerns, I believe, that arise in your concern about mitigation sites, because it goes to the installation and maintenance of aesthetic mitigation. Are you familiar with the latest version, which was effective September 1st, 2017?
I think I have seen it. I don't recall the specifics, but
Okay. So you did not review this document, which may or may not be applicable even in this case, to in your assessment of, or in your recommendations regarding this case?
not specifically. No, I looked at really what I felt from my experience, again, as a landscape architect, would be required and necessary to mitigate undue adverse effects.
So you can't say whether or not, if we directed Chelsea to, condition Chelsea, a CPG in this case, on observation of this requirement, whether or not that would meet your concerns.
Not without reviewing it.
It was only 3 pages.
Um,
Why don't you take a couple, 10 minutes to look at it,
okay.
and I'm gonna talk with the parties about briefing schedule.
Do you want to discuss that
We're
first?
gonna go off the record now.
Okay. I had, just as housekeeping, I have the 2 exhibits from yesterday, Exhibit A and then the settlement. Exhibit A is the stipulation of evidence. I'm just gonna give those to the clerk.
Does she have the GPS 1, 5, 6, 10, 11, and 15?
She has
Across
the whole
exhibits?
thing, and I can take out the ones that were admitted. I asked for both. Do you want both? No, I said I answered both. Yes, Joanne.
She does too.
No,
Okay.
it's fine.
I think you should.
There were some cross exhibits that were responses and requests to admit filed on the department that were responded to, and they were in our process. And I talked to Mr. Porter about that. We agreed that we would bring that up at the end of the day. I haven't heard his response yet, but maybe we can do the briefing first. And then
I'll tell you quickly if this is helpful. 20, 21, 22, 23.
Wait, okay. You're talking of the discovery answer number.
Is that what we're talking about?
No, you're right, 20, 21, 22.
23. 24 and 25. I think I was strenuously objected. 26.
Well, they weren't addressed in cross.
That's because they were signed by council.
Which was a part of the case as part of this. The other ones, I don't think we care. Just 26, 27, 28, 29.
So the department's admissions to discovery, what's the ground for objecting?
Can I ask what you guys are talking about? I
Yeah,
have
do
no
you want to
idea.
look at them? I mean, you got them.
They're DP, yeah, they're exhibit CS-Crocs-DPS 20.
When you and I were outside of the break, these came back, or were in the stack, weren't they? That's the first I heard.
She has all of them. There's a list, an exhibit. I
Oh,
didn't
they're
know
at the
front on
very
the back.
end of
I
the
didn't know it was
stack
some-
of
What
exhibits.
I didn't know there was something on the back, sorry.
They're like sort of one-pagers.
So we're being asked if we're going to object to the admission of these documents.
Yes, I think so. Certainly 23.
I can tell you that I'm not gonna admit them because they weren't addressed in cross.
That makes it easy.
They were not executed by Mr. Raphael. They were signed by council.
And why does that make a difference?
He did not answer the questions.
They were not addressed in cross, therefore they're not cross exhibits. So I'm not gonna entertain a request for admission of those documents.
Do you mind, Jim, I gave you my copy. Can you
I
provide me
give
with
it
this?
back.
These?
It's just 2 through 2.
20.
20,
Not all of it.
yeah. So, had discussed, and I should have told the hearing officer this, but I had discussed with Mr. Porter that we were gonna have a discussion about this. I wasn't aware that the department was going to object to these.
Well, I will object and nobody spoke to me, so, you know, you've done your cross, we're done. Don't get third bite at the apple, so. I don't know.
It actually is, I'm not trying to be huge, we were trying to be respectful of all the time limits and let cross-examination continue and raise this. I don't think it would take very long for me to ask the questions, and if the witness is able to answer them, he can answer them.
Well, these all appear to be documents that he has nothing to do with,
Which is why I didn't ask him the first time around.
which
These are
is why it's
admissions,
inappropriate to be crossed on it.
these are admissions by the department.
Well, that's something that you have to address otherwise. Okay, Mr. Raphael's indicated to me that he's had an opportunity to review Commissioner 5.800. I'd like to go back on the record and ask him some questions. Mr. Raphael, you've indicated that you've had an opportunity to review Commission Rule 5.800. Would the application of this rule satisfy your concerns regarding mitigation of the site?
It would, with the understanding that mitigation measures, obviously, that I believe are worthy of adoption to avoid that undue adverse determination are part of that.
Oh, absolutely. But
Okay, that's implicit.
This is the whole package.
Yes, yes, they will.
Okay. Questions in light of my questions and answers? And his answers.
One question, that your answer is just as to aesthetics, however, correct?
Correct.
This has to do with the mitigation
Yeah.
measures required for aesthetics. Any other questions? Very well, Mr.
Yeah,
Raphael.
if I may, there we go. So a minute ago, when I was talking with you, we talked about the decision of the Public Utility Commission in terms of the analysis and determining whether or not there's an undue adverse impact and where that analysis ends. Would you agree with me that the Quickie analysis ends at that point, and these further notions of whether or not massive screening could be incorporated is not part of that process if it was not proposed by the applicant, correct?
Not necessarily. I mean, it could be something that an intervener or another party wants or recommends or would like to see.
But if other folks contest the fact that even that mitigation would in any way remedy the concerns of either orderly development or aesthetics, would you agree with me that this is not part of whether or not the petitioner, having now a second bite at the apple, flunking the first time, now they've come back with a significantly altered proposal, and yet they still, and right now it needs to be determined whether they did or didn't pass the bar on its own merit.
I don't see how this is within the scope of the question that I asked, which was specifically limited to Commission Rule 5.800. So I'm not gonna, you don't have to answer that question. Okay. Now,
Well, could I just then ask one other question?
as long as it's within the scope of my questions that were asked with relation to Commission Rule 5.800.
Yes. Your opinion that you just expressed in response to the hearing officer's question about your concerns would be allayed, but what about in terms of the cumulative effect? Does this rule and what can happen with mitigation and alteration of that mitigation for screening, is that alleviated in terms of both of these projects and its cumulative effect?
That's a separate issue.
Right, but given that cumulative effect that you've expressed concerns about, is the mitigation...
I'm going to find your questioning outside the scope because it has nothing to do with mitigating measures under Rule 5.800. Mr. Raphael, I thank you for your testimony. briefing schedule.
Get this stuff in.
Yes.
I'll just wait till then.
There's a scheduling order that has the briefing schedule in place already.
Does, and they are?
October 5th for the first hearing briefs and proposed findings of fact in order, and then October 19th, reply briefs.
Are the parties content with those dates still?
Yes.
Well, a little tight, but
Would it be possible for the 19th to make the first, to make the
that'd be agreeable for us.
So you want another week for the initial brief?
What was that?
well, let's want another week for the initial brief, if that's okay with everybody.
Yeah, I'm not here that week anyway,
Okay,
that ends on the 5th, so.
so initial briefs would be viewed at,
I would propose the 19th for the briefs. Because, I mean, when are we gonna get the
Yeah.
transcript? Well, we need to get that first.
It's, yeah, normal delivery is 2 weeks, it's usually before that.
Okay.
That's 4 weeks
That's the 20.
for standard.
Initial brief on the 19th of October.
Petitioner's preference is to keep the scheduling order in place.
Are you gonna get construction done after the 1st of November?
I don't think,
If it's approved?
I'm not considering construction in the schedule.
Is it a financing issue?
No, it's just extensive delays in this particular proceeding, and I thought this order was final.
Well, it's been less than a year since you submitted the application, which is record time in comparison to some of the other cases. So it has been an expedited, and I'm going to allow, for that reason, I'm going to allow parties October 19th for initial briefs, and reply briefs will be 2 weeks after that, which is
November.
November 2nd. And I would anticipate that the parties would do proposed findings of fact as well as part of their initial brief. Questions?
I think that guarantees that we're not gonna have a final order from the commission until next year.
No. If the, well, I suppose that's conceivable, it'll be 2 months from November 2nd. I'm thinking more like Christmas time. But you know, if the commission approves Apple Hill, that will be out there available to work with, and then, you know, unless there are, again, that's still a year of within when the initial application is filed, which is record time for a highly contentious project.
Correct me if I'm wrong, the commissioning deadline is August of 2019,
Under the standard offer contract?
the most recent commissioning deadline. Might be wrong. That plays into what,
Yeah, because it's been extended, it was extended, but with caution.
there won't be a second,
Right, that's what
The commission won't go on under this. Okay. Then I'm going to go back on the record and state these dates, and then we'll conclude. Are there any other matters we can take up on the record before we adjourn? No, very well. We're record, while we were off the record, the parties addressed a briefing schedule that had previously been scheduled to sign. Dates in that schedule have been extended. Initial briefs will be due October 19th. Reply briefs will be due November 2nd. I anticipate seeing, to the extent the parties wish to do it, some proposed findings of fact as part of the initial briefs. I understand from the parties that there are no other matters to take up. This hearing is adjourned.
Thank you.